Hit that like button and subscribe if you haven't already. We're not going to waste too much time. Shout out to the people who support the broadcast, of course, and on my Patreon, the people who keep this broadcast going, and my moderators, of course. Shout out to the people out there who are learning a lot. There's a lot of people learning a lot, especially since we rewatched this short videos of talking about law, history, um, trust, jubilees, time, what these people are actually going for, the 13th and the 14th Amendment, and a lot of other things. If you got any questions, feel free to type those in the chat room as well. I'll read those out. If you out there, you feel me? So shout out to the students who are here. Shout out to Wish. What up, champion? Taj Payton. Shout out to Mandu. I see Miss Lori up in the building. C. Mosley, LT, Michelle Walker, Jeremy Woodward. Shout out to you, Anjanita Moore. Shout out to you. Let me see who out there. Urban Barker, Royal Purple. Greetings to you as well. Yeah, and it's important that people take this type of stuff serious. I mean, you have to think about these words and terms in a way that they were speaking when this whole construct came to be. Shout out to you, Casmo Star. What up, champion? My man. My man Cashmo, what up with you? I was just on my Xbox and I seen some old shit. I think it came up in my recommendations, like back in the day type of shit. Shout out to you. Oh, wait. Let me see who else up in here. Said Bernardo. What's up, champion? Well, a nigga seeing things a lot more clear when hearing these terms and things of that nature. And then you find out there's a huge swap going on. And people don't want to be 14th Amendment citizens because of what? Tell me why. Who's dealing with right, being. I'll let y'all tell it. What's up, Marcus Johnson? What's up, champion? Good to see you, DNS Brands. Good to see you, too. Who is this? Fame. Good to see you, champ. Moshe Black. Let me see. And shout out to the people. Ali Ware, what up with you, my man? All right. Silent Assassin, you are in here. Evelyn Bland, shout out to you guys who were in here early. Fletchery Berkeley, B from Texas, SBDM Radio, shout out to you guys. And of course, the moderator, Stephen Coleman, what up with it? If you guys didn't watch the last video, this ain't gonna make no sense. Shout out to my students who understand, it's been a couple days for knowledge and wisdom to digest. Saturday and Sunday, we back up early. Monday, that's what's up. So without further ado, I'm gonna start this video because I don't want to prolong it. Hopefully the students are up to date. It's been 2 days. If you not, that's not my problem. That's not my problem. It's more like your problem. Wake up with the row every morning. Cavro University, 424-209-9506. If you got any questions, if not, then I shall proceed. What up, Mr. Crockett? Yeah, all I'm saying is, if you call my show or step in front of this classroom and don't know what we're talking about, just don't do it. Take a seat back because I ain't gonna do nothing but make fun of you. Obviously, you ain't paying attention. They want the right of being heirs, not the privilege of being a citizen. Good job, Mr. Marcus in the chat room. Shout out to you, champ. It seems you've been paying attention. It seems you're the only one who can answer the question, Marcus. Good shout out to you, sir. And you, as a black American, don't give two shits about what the only air you think about is Nike Air Jordan. Like us. I got Jordan, Nike Airs all over the place. I ain't never really thought about what an air is outside of Nike Air, press one, and the air we breathe. Never really gave it a thought until I started connecting the dots of our missing history with a stolen legacy. What's up, Mr. Bay? Everything is good. Taking class slow. Got a great support team. Everything is great. Shout out to you, Champion Fletcher. Shout out to y'all, man. Everything is great, man. Just moving along, progressing along as I should. No rush to get to a destination, for who knows where this mystery machine may end. I have no idea. I have no idea. This is just a influx of knowledge and wisdom and interactive activity. So, wherever this bus may lead, I'm near. I'm near. So let me get to the video. If you got any questions, you can ask them in the chat room. I'll put the movie on pause, answer your question. If you're too afraid to stand up, you can pass a note. I'll answer it. Coffee and Kush TV, Cairo University. Press 1. Pay attention. Keep your eyes open. keep your eyes open. This shit is keep your ears open. It's a lot of things that you can research within this, from common law to trust law to Black's law to shit. You don't even got to stop at the etymology of things. You can Google these things, 1828 dictionary. But the one thing that you must begin to understand is the scriptures. Press one. If you don't know, what I'm saying here is the scriptures. It's not an allegorical story. It's a legal manifest of destiny. Press one. It's not like a movie storyline with all of these allegorical concepts that Mickey Mouse have created for you. No, this has been a legal, historical shit that you've been involved in, and they turn your God and your history and the prophecies of what was to happen to you if you didn't obey the law. They turned that into an allegorical story, so you won't believe it. So you will be too busy in Wonderland and not in legal standing. Hit the like button and subscribe. Press 1. I said, so you'll spend your life in Wonderland. The perfect slave is somebody who spend their life in Wonderland. You never know. Press 1. You will never know. Spend your life in Wonderland and not in standing. And I hope that makes sense to people. Shout out to the people in the background, of course. And remember, going from the 13th and the 14th Amendment is very important. Remember, you didn't become a slave until they made you a criminal. Okay? That's very important. You didn't become an indentured, willing, free slave until you became a criminal. All right? You see how important it is? You see what it says here? In my mind, the heir of freedom can only be those born on the soil of the participating estates. Okay? Okay? Those who have a standing to claim it. Anyone naming the heir not is only stealing the inheritance. That's very important. If they're claiming, and what I'm saying is, anybody doubling down, claiming to be, how that sounds today, like a Native American. All of these Pacific Islanders and Turks and Polish people and Scandinavians and Slavics and people who are claiming to be descendants of this nation are participating in the theft of that inheritance. Okay? Very important. Very important that you understand that. And that's what we're showing here. It's important that you get this.
I never learned this in school. So there we have the fee simple absolute. Like I said, if they had named the heir, if they had done anything to signify who the heir was, it would have lessened the estate, and it would have become a life estate. Now, when you come to a life estate, you have problems because there are things that apply to it. You have responsibilities. To continue on with the fee simple, you'll notice on page 8, I have a few things underlined.
Now you don't get what she just said. If they name the heir, it'll lessen their estate. It'll centralize the power, per se. So they could never name the heir because it will centralize all power.
Such as if, now we're discussing the heirs or the parties of the estate, and if he dies intestate without any heirs, lineal or collateral, the property escheated to the overlord in feudal days, and now would escheat to the state.
So in essence, all you got to do is make the names obsolete. Maybe criminalize them or genocide them. As she said, they were genocided. Therefore, their names will no longer be remembered, and we can take them. They won't even remember their names. And that's what scriptures say as well. But I'll continue.
B's estate will last only as long as he has heirs. Therefore, we have the 14th Amendment getting rid of the heirs.
You got it? Did you just hear what she just said? Therefore, we have the 14th Amendment getting rid of the heirs.
The estate lasts only as long as there are heirs.
That's it. You got it? What a way to think about this.
That is why we hear from these offside roots that the preamble or the Constitution is outdated and outmoded. Yes, because they have gotten rid of the heirs and it is not valid anymore. Why should we keep it around? Let's get rid of it.
So there will be no need to uphold it. Don't even mention it. Because it'll make us obsolete. We either make them obsolete or we're obsolete kind of thing.
I heard by word of mouth, I don't keep up with these things, that one of the people who ran for presidency last time wanted to have a constitutional convention. Well, if the throne has been abdicated, a constitutional convention is proper, so that the throne can descend to something or someone else. Because we no longer need the Constitution as it is. It's outdated, isn't it? Mm. Well, you might think so, but I don't.
And another thing, that can possibly mean when you wake up, you can actually enforce the Constitution, and make them just as obsolete as you have been in the last 130, 40, 60 years.
On page 34, we come to a thing. You will notice that I have put some writing up at the top. It says restraint on alienation. Okay, case 40. A being, the fee simple owner of Blackacre, executed his deed to B as grantee in the following words. I hereby grant Blackacre to B and his heirs, but upon the express condition that it shall not be competent for B to dispose of or alienate said Blackacre for a period of 5 years after he receives the title of such property. Okay, so someone's attempting to pass a fee simple absolute here with a big but. But he can't do this or that or the other. So what type of estate does he really have?
He don't have one. He has an estate with limits.
And down there you'll see the answer is C has a fee simple absolute in Blackacre. This question does not involve either a determinal fee simple or a fee simple on conditions subsequent, for no intention appears on the face of the deed. Here is a fee simple estate vested in B. The grantor then attempts to impose upon the grantee, B, a restraint on his power to alienate or dispose of the fee simple estate. Is such restraint valid?
So he can't even dispose of it. So the whole act of making you a debtor is illegal.
Valid. The answer is an unequivocal no. You have no power, no right to restrain a fee simple absolute in any way, shape, or form. You can put no conditions on it.
And again, we're talking rehabilitation. When a person is ready, they're ready. If they're crippled this month, when they're able to assume who they are or their position, they can call it in at any time. That's the threat I'm saying you possess, and you don't know it.
Restraint on alienation. Pigeonhole that word.
And again, what is alienation? What's an alien? What is it to be alienated? It's all there in the black law, but it's also there in scripture. But it's also there in etymology. It's all there. They got you thinking about space aliens, don't they? Every time you hear the word alien, you think of a gray being because you've been watching Young Pharaoh. See?
Because at this time, your Social Security number is a restraint on alienation.
Everything they've done to you is a restraint. From dealing drugs and keeping you in a criminal mindset. From the 13th and the 14th of making and calling you black. It's all a restraint. It's all damn near you can get a restraining order on them. That's how crazy this is.
To that estate. Okay, let's see.
Get the page you're on, buddy?
I am now on page 79. We're going into freehold estates still. An estate of freehold is an estate of indeterminate duration other than an estate at will or by sufferance. Again, it says so, indeterminate duration. This is what makes the Constitution infinite, to last for all ages, for all societies.
Unless they're genocided and they're no longer able to speak, like Agent Smith said. What good is a lawyer if you're unable to speak? Meaning you're barred. Meaning we're going to send you one of our representatives anyway, and you're going to take what we give you. Right?
Okay, this makes it immortal. It's beautiful.
It really is, because all you got to do is wake up.
It is an immortal thing. It's there.
And it'll never be not valid. Never. It'll never be not valid. Okay?
Life estates. Life estates. Now, I should have something on life estates in here. I know they're there. I hope we get to them. But we're going to throw something in on life estates. When you get to life estates, we have conditions on estates, okay? You can no longer waste. In a freehold estate, the fee simple absolute, the heir or the posterity, the person who has the estate, they can waste any portion of it they want.
Yes, because it's theirs. They can do whatever they want with it. They can do whatever that they feel with it. See, this is how big this is.
They can burn it, shred it, throw it away, give it away, anything they want. That's waste, okay? That owner can waste. But when it comes to a life estate, no. There is no wasting in life estates. No wasting in life estates. You're subject to duties, regulations, and laws. Wonder what kind of estate the 14th Amendment is.
Life estate.
Here's a good one.
What page are you on, buddy?
We're on page 80. Some of the authorities, this is the third paragraph down, in an attempt to exactitude. I'm not always good at reading. Okay. Have employed the term fee simple absolute in such a case or in such a way as to set it off as a distinct legal concept. Totally new concept. Thus it has been stated that an estate in fee simple absolute means a perfect title. It is the entire and absolute interest and property in the land. Interest in the land. Your rights and duties to it are an interest in that. You have no duties, though, in a fee simple absolute, so your privileges, immunities, or everything is an interest in the estate. Difficult to pay. Page 81. Second sentence, there can be only one estate in fee simple to a particular tract of land. It is an estate of inheritance unlimited in duration, descendable to all the heirs of the owner alike to the remotest generations.
So, wouldn't you want to know who that is and where you standing at? Wouldn't you want to know? You know what they say? We're talking nobility here.
And aside from the fact that it may be created so as to be defeasible and subject to executory limitations, or granted or devised subject to a condition subsequent, it is with respect to its duration and enjoyment as an interest in property clear of any qualification or condition. It has been defined as an estate of perpetuity, confining an unlimited power of alienation, that or than which no person is capable of having a greater interest. And down at the bottom in the footnote, you will see that an estate which must be a fee simple is absolute, complete, and self-sufficient.
Now you see why it was taken from you? It was taken from why the mass immigration? They took it from you and gave it to them. They stole it. They stole your names from you and gave them to foreigners, aliens, foreigners, all foreigners. They took your names and gave you. They took your heritage, your name, everything, and gave it to them. And genocided. First they made you a criminal and then genocided you.
An estate which must be nourished or kept alive by the grantee is obviously conditional or qualified or limited. This element of insecurity implicit in the grant impairs the totality and permanency of the estate, and such an estate is not a fee simple. Insecurity? Are you feeling insecurity with your estate? If we had our estate, we would not be feeling insecure.
And that's how simple it is. So what estate don't you have? These are the questions we got to ask.
And insecurity is running rampant in this country amongst people. Heavy insecurities. Not trusting the other person, not trusting your brother, your sister, blaming everything on someone else. He did it. Republicans did it. No, the Democrats did it. No, the Latins did it. The Spanish did it. The Mexicans did it. The black people did it. The white people did it. The Koreans did it. Somebody else did it. Nobody is taking responsibility. They don't know who did it. They have absolutely no idea what's going on. Oh, let's see. Use possession. On page 83 in estates, it brings up the use and possession of property constitutes a gift. Let's see. Oh, we have the metaphysical concept of title. I like that word metaphysical.
Now check that. The metaphysical concept of title. Now I want to ask all the black people out there, whether they Christian, whatever, Muslim, Kemetic, Indian, hasn't our whole life been metaphysical, spiritual jargon rather than legal title and deed? Everybody can attest to that. And that's how I'm proving it's not your religion. Religion is a man-made concept and made metaphysical. And metaphysical is law, deeds, trust, God made ghost story. So you would never get out of the religious prism. Press 1. Because everybody needs a little feeling. Nothing more than feeling. You feel me? Shit, spirituality damn near feel like love. You don't even know what the fuck to do in a relationship because the love people got is a religious Disney World concept. A Disney World concept. But I'm telling you that religion is legal law jargon made ghost story. And we got to come out of the dream world to deal with this commercial entity.
For a long time, I thought metaphysical meant the whoos. You know, I didn't understand whoo, you know, until my good friend said, metaphysical means thinking. Thinking? Thought process. Okay. I like that word. I can understand thinking. It seems like that's all I ever do.
Okay, did that make sense to my Kemetic people? Thinking, thought, metaphysical. So when I say I don't thought, I'm thinking. Or I don't think, I thought. Or I'm just playing with the same metaphysical concept. Nothing to do with the legal jargon. And this is how these ghost stories, false Freemasonic, non-building, they only build in the metaphysical. Press one, they only deal in the mind, in the made up. And you leave man there long enough, he'll think about any and everything, and his ass will scientifically prove it by way of what? Thought. Again, all religion, made up jargon stuff taken out of legal and lawful concepts that you're supposed to be abiding by.
Well, if you quit, you're in trouble.
Yes, I believe so. I'm passing on to more page.
I'm not saying your what you believe is false, or you know what I'm saying. What I'm saying is, it's okay to adjust your metaphysical, spiritual sense and throw that so-called energy into a new realm in which your melanated chakra ass can think and thought some more. Press one in the real world. You can keep that. I don't care. But apply some of that pressure in the knowing that apply some of that spell work in the Black's Law Dictionary. Press one. Apply some of that horoscope and all of this mischievous metaphysical energy concepts. Apply some of that right there in the 1828, if you can, and an etymology of things. That's all the Moors are saying. Apply it there. Go. I don't care. You can dream world sometimes. It's gonna take a while for the serum to kick in. And go ahead. Go back to sleep, my child. But it's okay. But begin to adjust some of that energy right over this way into the legal jargon, because that's where you're losing. This whole battle in America has been one hell of a legal dispute. Would you agree? Press one. It's been one hell of a legal experience. And we're looking in the future at the theater of it all. You know, it's been one big legal matter. Even in Amistad, give us free. If an African can say that and they, what? All he had to say was stand up with chains on, give us free. Nigga, it's 2023. We got the internet. If the slaves had the internet, if the niggas in Amistad had a smartphone, like these niggas in jail got smartphones, they wouldn't be sitting up there talking about how many bags of Frito-Lay chips they have in noodles. Press one and the jailhouse spread. That's for sure. Press one. But I'm just keeping it 100 with us. We have to adjust some of that and see how God really worked legally.
Okay, exception to the rule, reservation of the grantor. Here, we must understand exceptions. Okay, on page 90, the common law rule requiring words of inheritance in a conveyance to pass a fee simple was subject to many well-established exceptions. Thus, although it was usually held that words of inheritance were necessary to establish a fee in a grant containing a reservation in favor of the grantor, because a reservation is technically speaking a regrant of the property, no words of inheritance were necessary to establish an exception in fee simple in favor of the grantor, since an exception excluded from a conveyance that which would otherwise pass. Now, in the Constitution, the Fifth Amendment and certain things are exceptions. That power that was reserved to the people is an exception. Okay, now exceptions are very important when it comes to the estate. Okay,
Only exception our people know is how to make a few $100s extra in a tax return. Press 1. I'm sorry. Only exception we know is check this box right here and press 1. Come on, y'all. Wake up.
even though they put words of inheritance in here, okay, there are still found exceptions in the body of the Constitution outside of here. And we must find those exceptions at time. In the Fifth Amendment, you were reserved. This is, by the way, this is where liberty is in the Fifth Amendment. I had a couple pages of index on the Constitution, what is found where. Liberty is only found in the Fifth Amendment. That was interesting. The let's see, the blessings, where is it? There, nowhere in the Constitution is found domestic tranquility. There is no corporate power to administrate domestic tranquility.
Press 1. Now, if I was in jail and I heard that person, my attorney, say, Kev, listen to me. There is no corporate power that can. Press 1. Wait, what? Yeah, they can't. It's not even legal for them to think they can administer nothing. Because of the preamble. Because of the contract itself. In religious term, remember the covenant. I'm telling you right now, remember the contract. You don't know the contract. And if you don't know the contract, you're ignorant. And ignorance is no excuse. Of the law. That's what. Press 1, damn it. So it's up to you. You don't have to do anything but wise up. That's it. You don't have to stop working and I'm an entrepreneur now. Yeah, no, bro, continue on. But wise up in your mind. Start paying attention. Like the truck drivers hit me with so many photos of old Germany and the old right here in America in the old world that we call it medieval. Press 1. In the old world, which is you. Wake up, family.
Yet it's in the preamble. It's part of the estate.
There's nothing to fear but fear itself. It's when she say it's in the preamble, that means it's right there in law. Damn it. They can't even have no corporate power over you. That's what she's saying.
It's supposed to exist. Obviously, we're not getting our domestic tranquility these days, but yet it is part of the estate and is not listed anywhere or even under any subject of the remainder of the Constitution. And liberty is only found in the Fifth Amendment. Now, the common defense and everything, all these other words, common defense, general welfare, that is enormous, and that is what they're administrating under the corporate mortmain jurisdiction. But
Did you understand that? It just made me think of how all these trillion and billionaires in Dubai are creating all of these palaces. And is it really not about oil? Because us in America be like, oh, they got it all from oil. But from under the sand, where they get it from? I'm telling you, they got it from right here in America using international shell corporations by way of Disney and media corporations and other things. Press 1, which is treading on your right, which is against the beneficiaries, is a tread on the laws of this land. Press 1 again, like again. So here you have angles in chess you can maneuver through as a person here at Cavro. Lots of angles of possibility of argument per se. Do you understand what I'm saying? Can we upgrade our language a little bit as I smoke on this weed though? Now you can see the chessboard. And wait a minute. This is nigga, you can't even come across my press one legally. Press one. It's important for you to understand commercial, law of water. Press one, but the land is superior. The corporate infrastructure may have gotten you to believe that their policies is your law to abide by. They got you to believe that a woman is king. That the monarchs is Queen Elizabeth's estate get granted to by King Edward or King whoever. Press one. It's a stolen legacy. It's a stolen patriarch. I want my audience to do one thing. I want y'all to open up a new tab, go to the 1828 dictionary and type in matrix. Let's do it together. Let's do it together. I put it on pause real quick. Put your brain on pause a little bit. Let's go open up a new tab, go to the 1828 dictionary, all of us together. So y'all don't think I'm making this stuff up. Okay. Yes. Charitable trust. We got it, Brittany. Thank you. Open it up to the 1828 and type in matrix. Can you do that? So all of the matrix is the body of water. This is pretty much the body of water we're speaking of. So when you say what is the matrix, you have to consider the legal definitions of these things. When you watch the Matrix, don't watch it like a sci-fi. Watch it like you Neo, like I've said, under a legal restraint of not knowing how to maneuver in the real world. You got it? Gotcha.
Several of these things just aren't being administrated under corporate function. It's kind of nice to know that they have something they can't administrate. So when I write to them, I'd like to have my domestic tranquility as part of the estate. Now, am I going too slow or too fast for most of you? Am I doing okay? All right. Oh, here's a good one. It's page 91, up at the top. It says, a grant to the government.
Now, we went there, right? Now go to matriarch. Press one. Press one. Now go to matriarch. I want you to see it from the metaphysical. Now go. I want you to see it how they did it from the metaphysical and they beat you. All right? That's what I want you to see it from. Now go to matriarch. Or, matriarch. Mother or woman who heads the family or tribe. Press one. Well, watch this. This is how they got you, black folk. Look. Matriarchal as an adjective or pertaining to maternal rule or rule by females. Press one. Let's go to matriarchy as a noun. Press one. Government by a mother or mothers, form of social organization in which the mother is the head of the family and the descendants are reckoned through the maternal side, formed in English 1881. Press one. It's patterned after the patriarchy, so it's reverse. It's the church of what you do now. It's the upside down, inverted mother. You see that? That's why they're hitting you with the Tupac, Dear Mama, and the matriarch rule. You're supposed to have a king over you, but you have women over you. Especially in the black community, what did God tell you in Scripture? You know Scripture. And that's a curse to have women rule over you, matriarch. Press one. See, I got it. You all checkmated. That's in Scripture. That's a curse. So you're not even supposed to be thinking about woman king. You can't serve two masters. It's impossible. Press one. Now, what do you think the patriots are? What do you think all this is against now? You already know Mother Russia. You already know the Catholic Church is seen as the mother church. In the scripture, talk about the mother harlot. So use your head. If you don't believe in God, you'll believe in you. If you don't make this connection between scripture and legal stuff, and you're staying in the allegorical Disney World Wizard of Oz way of life, you're gonna miss it, because the scriptures is the key. The answers is right there in law, and it's in legal jargon. And you can sit up there and praise God, but faith without works is dead. Press one. Hit that like button. I'm burying them. Boop, bop, beep, bop, beep. Oh, you can look at that. Look and see that. I'm like a battle rapper constructing this from the press one. Hit the like button. Oh my goodness, then I feel good. I feel good. Faith without works is dead. You can't sit there. You hear me, Brian King? Boop, bop, beep, boop. Watch out. Just back up. Right, check left hook. Watch out. I got him like Ricky Hatton right now. You can't sit in Wonderland and want to be free. You can't know God without law. And you can't see the kingdom without the scripture, without God. Without understanding the legal matters of a kingdom. How societies run. And why they run the way that they do. And why you think the scripture places so much emphasis on the man being the head of household. And we already know, black people, they took the head of household. What? Now you understand. Now you get it. They made the head of household. We just did our taxes. We just did it. Press what? Women. They don't need you to be married. They want to separate you because the man is inserted as the head of household. They don't want that. They need you to believe that you being independent and y'all got some type of inner relationship issues out there in the world. Press one. All over YouTube, all these problems. That's a covert Marxist ideology. They don't need you to come together. I'm telling you, go watch the end of Matrix. It's all about keeping Neo and Trinity separated, close enough to keep her materialized and confused. Press one, fucked up. Him ever so yearning for love and affection and shit. Press one, got your ass in real time. Your ass up in the Sistine Chapel, like a real holographic motherfucking sculpture or something in real time. They got you in bullet time. I mean, you trying to figure out what is the problem. First of all, the man is not the head of household. So he's dethroned. This is how they cut the heads off the Negroes. They took your last names and bam, alienated you, which is against but we'll get back to that. So when they came and disorganized the family the way that they did, by way of paper genocide, because if it ain't in black and white, it ain't real. You got me? So it must be done that way. Marriage license is a contract with the state. Sir, a marriage license is a contract. Everything is a contract, sir. The United States Constitution is a contract with the estates. So you have to come into the estate together in order. Press one. So don't let the word contract and by the state stop you from the blessing. Those are just words. Everything is by way of contract. Whether I shake your hand and we agree upon it, or we sign to, that's the correct way of doing business. That's not to be afraid of. That is to be embraced. See, Michael, we was raised in a matriarch where all the males are afraid of paperwork. You see, Michael, you proving my point. I'm not against you. What I'm saying is that way of thinking have made us afraid of paperwork and being the head, or what these women say during these shows. Lead me, damn it. Press one. Oh, I'm crazy because we don't got no damn leader. Oh, I'm going back to the streets. I can't take it no more. You know why? Because every one of you niggas these females date, only thing y'all know is sports and this one and this one. And they think about sports. But tomorrow, it's back to business with these women. That's what it is. And so you can't be on motherfucking sports and WWE if you ain't in position to do so. With most niggas ain't, you got to be back at it. That shit ain't real to them. They'll make the chicken wings, but tomorrow is get your ass up. Hey, the love is gone. Back to it. Press one, Michael. That's what it's about. Shout out to my Cash App and my Super Chat going off at the same time. Kelly Green must think I'm telling the truth because she's contributed to the page. Who was this in my Cash App? Already first thing in the morning. My man Taj was up in this thing. Wish, Bishmallah Holloway. Brian, shout out to you, King. Yeah, Yah's chosen. Thanks to you, champion. Yah's chosen. With a $50 contribution to the program. Shout out to you. Lord have mercy. That's what's up. I'm just trying to tell you, they pretty much like lead us. And without the law, without a legal perspective on how to make most of these females is powerful because they all independent. They can pay $600 for a weave. We can't sit back and say, why are you paying $600 for a weave when I got a $2,000 goddamn computer? Press one and motherfucking 250 goddamn dollar Air Maxes and Ken Griffey Jr. and shit like that. So we can't think about that like this no more. Press one and like separation and tit for tat little shit. Because you got to understand there's a war against the black family. What did Tupac say? We can't even have a black family no more. It's like, what's the issue with you two and why you two can't get along and why are you a single mama and why you don't take care of your kids and why you they're taking these broad statements and using them as attack. And you can't fight your way out of this by participating in the attack against yourself. Press one. That's why I make fun of them on my night show. I laugh with y'all and let y'all know these people cannot be serious about reality. That's because I understand now it's a greater responsibility dealing with this microphone and this camera and you as the viewer. So the attack is always in the mind and the separation of not black and white per se, really male, female. And to create these useless worldly arguments about shit you ain't even supposed to be worried about. Motherfucker get on the TV every day and worry about what gay people doing. Press what? What the fuck is you on my live stream recommendation? Talking about it's the feminization. When you the one watching the shit, you the one the program is working on. Change your mind. Go watch Conan the Barbarian or something. I don't know. Go watch Rambo. You can watch something, bro. Shit, don't just put your brain there. But let's get back to the script. I just had to, let y'all know a little bit. Incredible.
Or a subdivision thereof, as for the use of the United States forever, contains sufficient words to vest an absolute fee simple. Now, I want you to just pigeonhole this idea of a grant to the government, okay?
Remember that. Grant to the government to make this all work.
In the United States, the common law rule requiring words of inheritance and a conveyance to pass a fee simple has never been applied to a conveyance to a trustee. The estate taken by a trustee is measured by the duties he is required to perform. Like the articles. and the exigencies of the trust, and not by the presence or absence of words of inheritance. But yet there they are, still there. Hence, in any particular grant to a trustee of a fee simple title is necessary to the performance of the trust, a fee simple passes even though the word heirs was not used in the conveyance. Contrary rule is obtained in England, however. So the articles are the duties of the trustees in this estate. Supposed to have gold and silver, all those good things, as money.
Okay, so let's talk about that. Supposed to have gold and silver as money. Shout out to Our Khan. Shout out to you, Our Khan. Shout out to y'all in my super chat. Y'all know, I don't get no commercial or nothing. Shout out to Kelly Green and Our Kwan, and shout out to my Cash App. I'm gonna read the rest of y'all out a little later, but life is a trip, man. It's a fucking trip when you start thinking about this way. Damn.
And the exigencies of the trust, and not by the presence or absence of words of inheritance. But yet there they are, still there. Hence, in any particular grant to a trustee of a fee simple title is necessary to the performance of the trust, a fee simple passes even though the word heirs was not used in the conveyance. Contrary rule is obtained in England, however. So the articles are the duties of the trustees in this estate. Supposed to have gold and silver, all those good things, as money. That's a duty of the trustee.
Okay, so what have I taught you? What have I taught you? Are they in breach of the trust? Are they in breach of the trust? We're going to talk about what trust, whose trust, heir, and all kinsmen. We're going to talk about these good things coming up in this semester. But are they in breach of the trust? What have I taught you, or what have we discovered together? Not even what I've taught you. Let's say, okay, the bus driver is with the students. Okay, we're walking together in this journey. What have we discovered? Who took the gold, mate? And not only who took the gold, even worse, who took the silver? You see? You know how they say you wasn't born with no silver spoon in your mouth? Where your great-great-grandparents were. Oh, my goodness. This is your great-great-grandparents were. And they did. Trust me. And they were made to turn in their golden whatever. From gold and silver sporks and spoons. Trust me. So, when Grover Cleveland signed away your gold to an offshore, bear with me, press 1. Now listen to me, Albert Khan, Mrs. Green. When Grover Cleveland, see, we discovered that there. See, I was paying attention to our work. When Grover Cleveland signed our gold over to J.P. Morgan and Chase Manhattan, that was illegal as trustees. Press 1. Because they are supposed to be keeping that to the beneficiaries and distributing that appropriately. That's the importance of just follow the yellow brick road. You follow the money and the who, what, where, when, and why. And we've been doing that this whole time, which is another blessing. And blessings is just testimony of revelation. Press 1. So again, there you go, epic treason. We had callers call in and talk about international corporations that were so-called American, that was in business at the time with Nazi and Soviet Union infiltrators. Press 1, which is treason. Treasonous acts. These corporations and corporations after corporations are still at play today. Even dealing with the petroleum companies who fund a lot of the YouTubers these conservative right-wing people come from and left. Oh, it's not just George Soros. But if you don't establish law and learn the language and learn how to deal with each other on this level, you'll never be free. Ain't no time to gang bang when you're thinking and talking at this level of intellect.
Very interesting. Gold and silver is the trust fund, the money, okay, if that's the money in this estate.
So if the trust fund has been robbed, you need to know who, what, where, when, and why. Because in the future, this will be used in court. These informations will be used in court cases. You see? New people will say, what? New thought and new metaphysical process will arise to be placed on this real legal jargon that we seem to be in quicksand in.
What is a Federal Reserve note? Who is Federal Reserve note for?
It's a breach of trust. Why? Because it is a debt note. You got it? The Federal Reserve note is a breach of trust because it's a debt note. You see? Because it's a debt note. And that's not what your forefathers are, the king. So they disregarded the king and the real church and the real God and the real, to go along with a corporate, religious, metaphysical, allegorical, oligarchy, matriarch, caught up in commercial law of the sea, which is piracy. And again, all made illegal under the king. And how did piracy law supersede the law of the land and common law and things of this nature? Well, you've been living in a dream world, Neo. Press 1.
Yeah, but that's a name. What's the thing? We're looking for the things that the Constitution creates, not the name. 14th Amendment is another estate. It's a separate estate. It is a life estate.
What's on the screen? A sub-estate, if you will. The only aspect of the 14th Amendment that is lawful.
It is an estate created under the estate.
Right after the 13th, right? I mean, let's do the Sesame Street math. 14 come after 13. We were just talking genocide. What happened to them? Genocided them. Why? So you can create a sub-estate, right up under the estate, a ghost ship, per se. Do you hear me? Do you make sense to you, Pirates of the Caribbean fans out there? A ghost ship, per se. You see, it says a sub-estate. Where's that? Under. Like submarine. Under. You with me? Which is against, and again, a breach of trust. Who are you to create? That's like taking my name and creating another fucking bank account. Like Wells Fargo and fucking chasing them got caught. Creating more accounts out of yo shit. What the fuck is y'all doing? This is what we're talking of on a huge level. Just open up account and began laundering money through these accounts. Press 1. That's what they've been doing. Cherry Edwards makes sense to you, don't it? This is what it is. This is why Epstein and them, this is why chasing them in trouble, because they've been laundering illegal. This money is all ran off of trafficking, drugs. This goes all the way back. And this is huge. Okay?
If I own a fee simple absolute big chunk of land and I wanted to maintain control of half of it or 3/4 of it, and yet give maybe a quarter, sell a quarter, convey a quarter to
Lease a quarter.
someone else, but still get it back.
Yes, after 50 years, again, dealing with the King George Jubilee Trust. They want you to think you fought against the king. No, you didn't. You just went to sleep. That's all you did.
I'd create a different
You,
estate.
you died with the king.
Estate. You
That's
can
what
have that estate until such and such time, and if you die or the conditions aren't met, I get it back. So I create another estate. That's what's happened. Another estate has been created. On page 207, the non-payment of taxes. Ooh, my. Now we're discussing a life tenant here. The mere refusal of the life tenant to pay taxes is not where they're...
See? Now we go into life tenancy. See? Now you got to do what? Pay taxes, not tithes. Not tithes. No, you paying taxes now.
There has been no actual sale for taxes, a ground for forfeiture of the life estate at the suit of the remainderman. Next underlined portion. Under some statutes, non-payment of taxes by a life tenant is regarded as committing waste, justifying forfeiture of his estate. Well,
see why they come and take everything? They gave them power over your dumb ass. What? Like, yeah, but you don't pay your tax. We gonna come take everything from you. Everything.
they're not going to have you forfeit your 14th Amendment estate, so they just put you in jail. You've committed waste, now you're subject to certain laws and conditions.
Now what? You got to work it off, and then they tap into the estate and tap into what estate? They tap into it because, every day in jail, the federal government makes money off of you, and the state penitentiaries make money. Well, how are they able to make money? What are they tapping into? What are you giving them permission to tap into that you don't know? That all this work you sign in and all this forfeiture of your right and all of this, what are you giving them access to? You have to realize that.
Okay, as a 14th Amendment citizen, a life tenant, you're committing waste. That's against law. Even in old common law, it was against the law. So you see, we're at the common law, but yet we can't get to the common law. It's a paradox. The common law we want to get to is up here, way up here, but yet we're still at the effect of the common law.
Because we've been barred and you've been cut off. Because you've forgotten the law. AKA, God would say, you've transgressed the law and you have forgotten the covenant. And you have been allowed yourself to be alienated and overrun by the world. And taken on the concepts of the world. You see? So in law, this is what happened to you. In scripture, this is the spiritual aspect of what happened to you.
Because it's still hovering over us. They've just diminished our estates and we didn't know about it. Have not been informed. Full disclosure did not take place. If it did, certainly wasn't in my civics class. Now, under life estates, there are remainders. Okay, if I have a home in a life estate, I have to keep that home up in good condition for the remainders, whoever buys it, whoever gets it after me. a frequently stated rule on page 220. A frequently stated rule is that the remainder must be created by the same instrument which creates the life estate in the ancestor in order for the rule of Shelley's case to apply. Now, the rule of Shelley's case is long and drawn out, but it's a highly important rule.
Look at that. We was talking about the remainders, but look, are the remainders under the 14th Amendment Congress? Lord have mercy.
Under this rule, a will and codicil are considered one and the same instrument. Okay? It has been stated that the limitation to the heirs may be made by a power of appointment contained in the same instrument. So the rule in Shelley's case is important, and I'm not going to go into it because we have right here quite a bit to go through without going into everything I read and learned. Now we're getting to the point of codicil and will. Okay, all of a sudden that has popped up into our little picture. We're not quite sure where it fits, or even if it does fit, it might belong to some other puzzle, so we're going to sit it over here temporarily. And now we come to American Jurisprudence 2D, which is volume 23, Dedication to Desertion and Non-Support. But we're going to be looking up deeds. We're going to find out what a deed is. You see, all of these things that are very important when we're looking at a trust, at a use, we have to look at what is a will, what is a trust, what is a deed, because deeds start coming in, and so do grants, and so that everything can come into proper perspective. Okay, so in deeds, what if I was wrong? What if this was a deed? Actually, it is. Okay, it is a trust. It all comes in. Up at the top here, grant is a synonym of conveyance. Do you remember back when Mr. Baldwin said it was a grant?
Let us know what page on.
82.
82.
You missed that one. Remember Mr. Baldwin, the Justice Baldwin said that the Constitution was a grant? I do believe I read that. Right here in deeds, it says, grant is a synonym of conveyance. So now Blackacre has been conveyed. We now know it is a grant.
Making the corporation nothing other than maybe a trustee. Makes them another breach of trust. I mean, if it's a grant, it's not even like... And where did they get the grant from? They got it from where? You can't get rid of the king and say, oh, yeah, we fought against... Then come up with the kings and queens back over in London some goddamn way. Oh, yeah, we And then the Brits fought against the Nazis and the king and queen. And then we find out she is a Nazi, so nothing in history is even making sense anymore. Hit the like button.
Okay, and we find this under deeds, so obviously it is a trust deed. Doesn't have to be, but it is. This is very flexible, folks, unlike the law we know today. You know, we can take the word deed out and still say this is a trust without the word deed in there. Somebody brings a grant in, okay, it's a grant too. Yes, it's a trust, it's a deed. There are things that it is not. But there are many things that it is.
So, a trust, deed, all of this is together? We were talking all of this is in this contract? Trust and deed and all of these things?
Assignments. Section 5. The term assignment, which signifies the act by which one person transfers to another or causes to vest in another his right of property or interest therein, is sometimes used synonymously with grant. Again, so as to operate as a conveyance of the title to real property. But is ordinarily limited in its application to the transfer of intangible rights.
It's kind of like they can't manage their stuff, so we're opening up a grant. We need a grant or a 501(c) charter to maintain their account or estates, because they can't do it on their own due to reasons. They need to be in a damn asylum because and remember, it's the process of getting you out the way so foreigners become the beneficiaries granted by the trustees, which is a breach of trust to the beneficiaries of the king. Again, the king is given to you by God. Even in the scripture it says the kings are put over you to listen, to obey them. Yeah. They are the administrators of law.
Rights, including those in action and rights in or connected with property, as distinguished from the property itself. The term assignment, unlike the term deed, does not signify an instrument under seal, and at common law, if not under seal, it was not sufficient to pass legal title to real property. This document is a document under seal.
Let's go back and listen. Try our best to listen to that just a little bit.
But is ordinarily limited in its application to the transfer of intangible rights, including those in action and rights in or connected with property, as distinguished from the property itself. The term assignment, unlike the term deed, does not signify an instrument under seal, and at common law, if not under seal, it was not sufficient to pass legal title to real property.
Oh my goodness. I would have to listen to that 50 times.
This document is a document under seal.
So if it's under seal, what does that remind you of? Those seals need to be what? When you talk about documents needing to be unsealed, but we're talking historical unsealing.
Oh, then we have mention of wills down at the bottom of page 83. Under deeds in Amjor, we have wills. Okay? Whether an instrument is a deed or a will depends primarily on its operation and not on its form or manner of execution. The essential characteristic of a testamentary interest is that it operates only upon and by reason of the death of the maker. During his lifetime, it is ambulatory and revocable. Hence, the maker, by its execution parts with no right and divests himself of no oh God, this is getting different. Modicum. Modicum, how do you pronounce that word? Modicum? Modicum?
Modicum.
Modicum, okay, of his estate. I see, I'm not all-knowing. I'm not, even though you might think I am. After you know what I know, you're going to be a know-it-all too. It is fundamental, on the other hand, in order that an instrument may be operative as a deed, that it pass a present interest, although it is not necessary that the grantee take a present estate in the property conveyed accordingly. This is defining deeds and wills. On the operation, what was the primary operation of the Constitution? Besides, the Founding Fathers did not have testamentary capacity. The Statute of Wills says that. But now we're segueing into, we're bringing in a little bit of will stuff, because we're going to find out that the 14th Amendment creates a codicil. It is a codicil. The Founding Fathers are obviously dead, folks. They must be dead because everybody is taking under a codicil and looks like a will.
Yeah. Insane. Now, you wasn't taken under a codicil. You were blackballed. They were taken under a codicil and giving new life and taken after a will that wasn't theirs. What will? What will? Well, I keep telling you, the Holy Scriptures is a will, a deed, but it's just a will, a living will that still stands today. They've taken something and they've taken inheritance and property and finances and gold and silver and oil, the blood of this nation, and made it their own back home.
Part of our document. It's segued. They must have died. We're going to find out that the 14th Amendment is you make an election to literally take under a will. Page 90. Deeds are traditionally regarded as consisting of a number of formal parts. The first of which is known as the premise. The premise of a deed, sometimes designated the caption, embrace matters preceding the habendum clause, such as the recitals of the grantor, intention and motives for his deed, the names, designations, and descriptions of the parties, etc., the conditions expressed for the deed, words of grant, and the description of the property conveyed. Okay. Yeah, it defines it. Defines the property conveyed. The Constitution appears to have a habendum and all these things that are in deeds. Okay. We're looking at the construction of the instrument. This is how the Supreme Court looks at things. Words of grant on page 91. In order to transfer title, an instrument must contain apt words of grant, which manifest the grantor's intent to make a present conveyance of the land by his deed as distinguished from an intention to convey it at some future time. This showed no desire to do it in a future period of time. This was right then, there, and now.
Always now.
Always now. Oh, and down here in the bottom in section 20, although words of inheritance such as to the and his heirs and assigns forever are no longer necessary to pass a fee simple, the use of such words
See? Yeah, no need to.
strengthens the reading of a deed to pass a fee simple title. Okay, so they strengthened even today, and not to amalgamate.
So when you ask yourself, how did the foreigners get a leg up on you? How did the foreigners get a leg up on you? Well, they were given land. Remember Martin Luther King said that the immigrants was given, they was brought here and given this? That's all they're redoing in today's time. They're redoing the early 1900s all over again. That's what they're doing. That's what's going on today. Giving all of the land and ownership and Social Security benefits to people who ain't put in it. And that's how you rob a nation. That's what they did in the early 1900s with the first and second wave of immigrants. This is Ellis Island, White Island, all of that shit dealt with what's going on today. And their children's children are looking back saying, hey, what's going on here, man? America needs to work this out, man. We don't need to be giving. Well, that's how you got here. You're going to have to admit that it's okay. They're doing what you did to these black folk initially. This has to happen. If not, then your great-great-grandchildren won't be here. And this is the thing that black folk, who you call black folks in America, need to recognize. they took under a will by way of codicil, press 1, by way of some catastrophe that may have happened that have knocked the royals out of commission at one time. It could have been what they were calling the Titanic, or those things that happened with those steamships at the time, which were insured by the Lloyds of London, of course. Again, J.P. Morgan and these folk. Pay attention. It's up to you to go back in history and see, wait a minute. So this just happened not too long ago? Yes. My point exactly. While you're thinking medieval, as long as you're thinking medieval, you're in Wonderland. This is right before World War I, World War II. A matter of fact, they just call them World War I. The Civil War and the Revolutionary War. All of these is the Great War. This is the big one.
Lesser states. Addendum, let's see, word covenant. Page 575. This comes from Amjor 2D again. You will find this under covenants. Covenants, conditions, etc. We have a covenant here.
And if you don't believe in God, how you going to see the covenant? How you going to see the blessing? How you going to see the inheritance? If you believe in this false system and matrix, how you going to see when you entertained all day in a little bubble? How? Let me know how you going to be able to see. You can't. That's why they made the movie. Because you ain't going to be able to see in the matrix. Unless somebody wake you up.
There is a covenant sitting right in here. Insure and secure. Those words are words of guarantee, insurance. The term
now it makes sense? Huh? Does it make sense now? It's all insured. Does it make sense now? I told you, the insurance companies.
Covenant in its wide sense is used to indicate a contract.
And insurances, but you see how it was made commercially.
While
to
the more specific application of the term imports an agreement deduced to writing and duly executed, whereby one or more of the parties named therein engages that a named act is already performed or is to be performed sometime in the future. A covenant may also call for the performance or non-performance of some specified duty, and may constitute an agreement to do or not to do a particular act. Is that in the Constitution?
Yes.
We have a covenant.
That's a moral obligation.
The term covenant is now used primarily in connection with promises, in conveyances or other instruments pertaining to real estate. You know, it says now, but not then. Then this was a covenant. Again, a covenant at common law imports an instrument under seal. We have a covenant. Duration of covenant on the next page, 577 of Amjor. A covenant is therefore extinguished when the estate ceases. We are in imminent danger.
A covenant is therefore extinguished when the estate ceases. Or when the covenant and the estate become vested in one person, or where that a recovery act of the land or estate to the covenant. Oh, we're talking redemption here. Press one. We're talking redemption here. Okay, that's what we're talking here. I want all Brittany. I love that you're invested in my chat room, but when it's time for y'all to call in, I see that you're highly invested. Right there, press one. I like that. So when I open up my phone lines, make sure you're invested, this invested right on these phone lines when it's time to check in. Let people flow. I know you know a lot, but I want people who don't know as much to be on it, to be that way. You know what I'm saying? We talking. You on every word. I got you. I don't even know how you doing it that damn fast. That's unheard of to me. But let people go. Don't do too much in the chat. Let people flow. You come after me every 3 seconds. Okay, boom, 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 boom. I got you. I got you. You right. But let them flow. You feel me? No, you good. Just let them flow. A covenant is there for students. We must understand the covenant is there for extinguish when the estate ceases. Did the estate cease? Do you think did the estate cease? No. The state must be kept alive. Press one? No. Their state is still at play. Do you understand that? The estate never ceases because it's contractual, it's by way of conveyance. That's how you end up with the 13th and 14th is by way of the estate itself. So no, everything is in play. And it has to be what? Redeemed. This is all dealing with Jeremiah and the scriptures and going into captivity. Therefore, the descendants of the people who went into captivity can be redeemed along with the land. This is the job of the Redeemer that the Bible speaks of. Not no other scripture on earth that the Bible speaks of. This is the job. This is what this individual does and is known for and speaks of and proves and all of that good stuff.
Wouldn't you say so? This is still on the books. It's still in black and white. It has not openly been repealed. But I have a very sneaking suspicion that our government is going to take our estate away from us or in black and white, or out of black and white, whatever way you want to say it. We are in imminent danger. We don't know what we have been arguing and fighting for until now. We can now look into the future. Okay, page 584.
See what? What can you see? You can look into the future, say, oh my gosh, they're actually trustees holding the estate for who? Oh, the ones that was genocided out in the 13th. Oh. So they're going to want their names back? Well, according to the legal Jubilee, it must be returned and deeds and this thing. Oh my goodness. That's what it's all about. You feel me? Understanding these concepts. You got me, Brittany? Is understanding these concepts right. This is what it's all about. Making sure you can see the kingdom, the coming of the Lord, the spirit of truth, the redemption phase, even even like again, and I'm not even talking biblical. This is all what you can see if your eyes can learn can see these words, and your mind can put it into unravel the legal jargon that surrounds it. Again, everybody been asleep this whole time. You've been barred this whole time by way of the bar association. Oh yeah, all the foreigners they over you, telling you, oh yeah, you're gonna take the deal, you're gonna take all the prosecutor ain't gonna, the state ain't gonna go with this and this one and that one. That's why y'all fill up the jails. It's important to make you and keep you a criminal and unable to see why. The why. You want to get free. Freedom doesn't come with a check from the United States government. It doesn't come like that. Freedom is something else. Now you may think when you find them a civil action or something like that, they owe you money or some kind of thing. But freedom is and liberty is above all that, and we got to get it together.
Let's see, second sentence. A covenant is viewed as implied in nature when its existence is inferred by legal construction from the use of certain words and phrases. Certain words and phrases. Insure and secure. These words are very important because they have a legal meaning. Every word in this document has a legal meaning.
Guess what? When you watching the news every day, and you listening to securities and these big old words, you're going to understand that these are all banking terms. These are all commercial policy terms. Yeah, you're going to realize that they don't place this commercial policy on your law and made it kind of similar so that when you speak your language, you start interpreting law through commercial maritime motherfucking laws of the water over the laws of the land. Thus, you are cut off. Again, God is telling you in Scripture what's going to happen if you do this. Not that He's going to do that. Well, yeah, this is going to happen to you, and I'm going to make sure. But it's more of this is mandatory. This is what's coming if you do not. If you make yourself a criminal and go after the ways of the world, they are going to subdue you. And they have subdued you by way of criminalizing you. You are born into criminal mindsets, dysfunction. Relationships just ain't working. Motherfucker don't even know what to do no more, you know? So we got to get it together.
When it comes to estates and when it comes to the construction of the written instrument itself. All the power of the entire Constitution is right here. Not elsewhere. Because this created the corporate function. This created the trust function. This gave all of it power.
Boom.
Page 585, second paragraph, or let's see. Implied covenants can arise and will prevail only where there is no exception on the subject matter of the implied covenant. This is something you should look into at your leisure. Implied covenants still count, even if those words are implied, they count. On the next page, 592. Reflects upon the 14th Amendment, okay, the marked area. At common law, no person may claim the benefit of any covenant or condition except where he is a party or privy thereto. As a 14th Amendment citizen, you are not party or privy there to this estate, so therefore you cannot claim the covenant. You are barred from it.
You got that? So that's why they don't want to be 14th Amendments no more. Because they understand, wait a minute, we can't claim the covenant? No, the covenant is given to the beneficiary. This is all Magna Carta shit. Wait a minute, so if white folks is barred from, wait a minute. Yeah. And unfortunately, those ain't your real names. Remember, the federal government gave you these names by way of immigration. You wanted an English name. Doesn't mean you are entitled to the right. Damn, that's deep. Damn.
Are you getting to understand why we're having a little frustration in court? We're having a lot of distress. Page 594, section 23 of Covenants. The benefit of a covenant that runs with the land descends to the heirs.
Did that make sense? The benefit of the covenant that runs through the air, that runs through the land, descends by way of heir. Press 1. You don't know this. Man, a monarch cannot do this. An heir to the throne is the king.
And they, as well as devices and
Remember, we're talking heads of household here.
Are entitled to enforce such a covenant unless an evident intention is manifest to confine it to the covenantee. In the event a real covenant is breached, then it descends to the heirs. The latter may institute appropriate legal action to recover damages for such breach.
Bingo. Which means the redemption process comes into play. We were just talking about breach of trust.
However, if the covenant is personal, it remains with the covenantee or his executor or administrator. It does not descend to the heir. Try to go through this. On page 617 of Covenants and Condition, 20 M. Jur. 2D, section 45, breach of covenants generally. The broad rule is that a covenant or condition is broken by any single omission of duty or any act that contravenes the provisions of the agreement entered into between the parties. We have a breach of covenant. This is what we entered into, and it has now been broken by many acts of omission and duties toward this covenant. Not toward the 14th Amendment, but toward this specific one. Page 629, we're discussing paramount titles. This is a paramount title. Okay? 14th Amendment citizenship is in a state of inferior title. We're going to find that out. The mere existence of a paramount title which has never been asserted generally does not amount to a constructive eviction. We've got to assert these titles, okay, which will support an action for breach of a general covenant of warranty. Or, as the rule is sometimes stated, there can be no recovery in an action for breach of the covenant if the paramount title has not been hostilely asserted. So we're going to have to hostilely assert our paramount titles. Section 59, where the paramount title is in a governmental entity. Where the paramount outstanding title is in a government, this fact of itself constitutes such a constructive eviction as amounts to a breach of the covenant of warranty. Now, wasn't that nice of them to put that right there in black and white? So they have breached the covenant, and they have breached the covenant of warranty, evicting us. We're just going to have to go back and assert our titles again.
You guys, man, listen to me. See, heart, I'm not talking about that right now. I'm going to put you on timeout. Focus. I see y'all trying to change. Check this out. Check this out. Focus. Focus. Here here to serve. God says 17 loans sounds like Dawes Rolls and Dawes Act of 1900s. Of course, this is what we learned all out here. So see Hart, sit down. We already learned that here. Okay, so just have a seat. You feel me? Sit down. You new here. I know the people who know we've talked about this, and the people who just new are not paying attention. You either gonna call in or you just gonna have a seat.
A grantee by warranty deed executed by a private person to lands owned by the United States cannot take possession without becoming a wrongdoer. Here's your allodial titles.
Cannot take possession without what? Without doing no wrongdoing. Because everything they will be doing to an heir of freedom is illegal. Does that make sense? She's telling you right now. Even though she's looking down at this book and saying it pretty fast, it is very important you understand the words that are coming out of her mouth.
And hence his right of action accrues immediately to recover for a breach of this warranty, and is not dependent on eviction or any future event, but under a statute providing that a warranty in actual possession of the premises conveyed shall have no right of action on a covenant of warranty until the party threatening the warranty's possession shall have commenced an action to obtain possession. We'll stop right there. Okay, so this is all about the breach of warranties and the covenants. Now, the next section is wills, but before I get to that, I want to read a definition out of Webster's 1828 dictionary of fee simple. Okay, because the question has arisen that fee was feudal, etc., and that it wasn't an allodial title. Okay. We'll skip some of this. Let's see. It's deduced from Saxon cattle, property, and fee, primarily a loan of land, an estate in trust. Fee simple absolute, an estate in trust, granted by a prince or lord to be held by the grantee on condition of.
Granted by who? A prince or lord. Now check this out. When they murdered Christ, what did he say? Because the prince of this world has been judged. Oh Lord, why have you, oh God, why have you forsaken me? All of this language is one and the same. And they know it. That's how they know. That's why they've been changing these things ever since. It's, they put Christ on the cross, or was he slew on a tree? Well, if you knew he was slew on a tree, that might be a little comparable to how we did them Negroes, and they might make reference to that. So let's say it this way. You understand what I'm saying? So let's say it this way. Let's make it look this way in the movie. If we say we hung him on a tree, because to be hung is to say you stand accursed. You will never see it. Your mind will be stuck in allegorical Disneyland forever, not knowing that this really happened. Right here. I keep telling y'all, it all happened here. You don't know how it happened. That's why we're here to help. I'm here to help. And people who send in information regarding what I'm discussing at the time is here to help as well.
Personal service or other condition. I'm not too sure what the conditions are on the estate here that we have. And if the grantee or tenant failed to perform the conditions, the land reverted to the lord or donor, called the landlord or the landlord. In America, where lands are not generally held of a superior, a fee or fee simple is an estate in which the owner has the whole property.
You dealing with holy land, in which we all just trampling on holy land with our shoes on. Don't know what we doing. We all, you know how they say the Indians tribal land and all of this? This is really holy land. Scriptures. Indians didn't know nothing about no damn scripture. This is real. And I'm standing on it. I've been standing on it since I came into. You feel me? I stand on this, 100%. Now I'm not saying I'm 100% right, but I always say if I'm right a little bit, I'm right a whole lot. Because this information, if we write a little bit, we right. You see?
Without any condition annexed to the tenure. In the United States, an estate in fee or fee simple is what is called in English law an allodial estate, an estate held by a person in his own right and descendable to the heirs in general.
So when you got these people talking about allodial state and finding your allodial state, they're looking for heirs. So when you see Janice, press 1. Let me get the camera. Where's the camera? So when the niece, what's her name? When Janice, the Indian tribal girl, press 1 is looking for niggas with allodial titles and this one and that one. They're looking for heirs, family. Now these people come from islands, from Haiti, by way of Africa and Ghana. Why are you looking for allodial titles from African Americans? You from way over there. What you talking about? Well, she's a treasure hunter. Press 1. She's looking for somebody who may have or be in possession unknowingly of allodial titles. Press 1. She's looking for heirs who don't know. She like the federal government. They like to look for heirs who don't know. You just living your life. You have no idea what the fuck your ass is. You know what I'm saying? So watch out for these individuals. I'm telling you. This person is a Haiti-looking person by way of Ghana or Sudanese. Press 1. Sitting up here trying to pretend to have a southern accent. Press 1. Like Cleo, call me now for a reading, mate. Press 1. Call me now. Let's get back to it. But that's the fee simple and absolute. That's what it's all about. This is why they want to marry into you. They want your name. They want your identity. They want your last name. So they can give it to one of their cousins. So they can get the benefit of what you don't know this is. You don't know. You're African American. All you know is struggle. Are you making it? You don't know what really is the ghost ship. What they really are doing. Okay?
So a fee simple absolute in the United States is allodial title. We're now going to discussion on wills because, like I said, I was looking to find out what was the Constitution, and the question had come up about. The question had come up about what.
And again, she just got finished talking about shit. If we don't stop this, we in jeopardy of being deported. Again, this little white lady, and we in jeopardy of being deported. We got to fight for our right.
Was a 1040? Was it a will? And I have to say, I don't believe so. But in researching it, I found a lot of interesting things on will. So we're going to go into that. Pardon me. Okay, page 275 of 79 Amjur 2D on wills. Okay, in there in the second sentence it says, by common law there were but 2 modes of acquiring title to real estate, namely by descent or by purchase. Where a person takes as heir at law, he takes by descent. But when he takes title to land by his own act or agreement, he is a purchaser. A little confused. Okay. Although in common application of the term, he may not have paid a consideration for it.
Like you purchased it. Is it the federal government gave away so much land, but on the deeds it say purchaser. They didn't purchase anything. It was given to them, but purchaser. Okay?
A devisee who takes an estate different from what the law would cast upon him as heir is a purchaser. You can look at the 14th Amendment as being purchased. The estate is purchased because you take something that is other than what would be cast upon you by the law.
Wow. 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 Remember, there's 4 parts to this. We're almost done. Wow. Okay, so when you look back on history, when did this happen? Now I'm talking to black people. When did this happen? Well, if you go back in my videos, we've been proving when this happened. Wow. It didn't descend upon you. It's not even legal. That's how important it is for you as a so-called black man to come out of black status and reclassification. Press 1 of all individuals is important. Amanda said it right a few grandmas ago. Press 1. A few grandmas ago. It was all taken. They call it manifest destiny. See, they don't want to admit because they don't want you to wake up and see it. But right here at this university, this virtual online YouTube university, you're going to see it. Because the information is going to override your brain. You're going to see it. All you got to do is think about your history. You're going to see it. When they robbed you, when they took everything, how illegal it was for Grover Cleveland to sign paperwork to give J.P. Morgan, the son of a banking tycoon, press 1, your trust, your beneficiary package. And then he loses it. There's a stock market, and then all foreigners are above you all of a sudden by way of union. Okay? And as crazy as I just said it, you have to be able to understand it and say it in your own crazy way. Because the first time you hear it, it may sound crazy. But when you get the knowledge, it's like, damn, it's so clear. So don't be afraid. No, it's no Mandela effect. Thank you. One more outburst like that, Mr. Kibo, you're not from this university. There ain't no Mandela effect. There's no conspiracy here. No. Mandela effect got you dweebs fooling around. No. This is something you can understand. This is real. This ain't nothing you gotta, did it say this or did it say this? Did it say this at this time frame or did it say this? No. This is what you've been living in. And with the right information, you look back at your life as an African American and say, whoa, this is what it's been all about. This is the why. This is why we were beaten and taken out. This is what civil rights was about. This is why we think the kings and queens of the earth was black. This is why Jesus was black and all this. And it all happened here. And guess what? You wasn't brought over here on the bottom of a slave boat neither. Guess what?
This is the law. Okay? And as such, under the feudal system, was exempt from the restraints imposed upon heirs in their minority, such as wardships and right of marriage. Although the feudal system had passed away,
again, dealing with words like minority and their capacity in minority. Go ahead.
hardly, I don't think so. Many distinctions of this character are still of recognized importance. It certainly is because it hasn't passed away. It is still in existence, and I look at the world today, and we are living in feudal times.
Now, you see that? Many state laws show that the common law of England is the rule of law. This one shows that there could be inconsistencies between them, but there is none. California Civil Code. So you're dealing with British, still under British rule. And what I mean by British, I don't mean those little funny little white people. What I'm telling you is you are the Brit. I've been saying it the whole time. You are supposed to be under the king. And all of them are in breach of contract, which is how those black folk in California were able to do what? Get their land back and make a judgment on the unpaid taxes and use of land. Press 1, back to them. Hit that like button and subscribe. It is part of the redemption process. Make sure you contribute to Gil's Gang on my Cash App. You want to shout out at the end of the show. We almost done here. Shout out to the people who's contributed. Man, can't ask for a better support team. Knowledge and wisdom is key. Not money, power, respect. Knowledge and wisdom. Man, I keep telling y'all, find out as much as you can about common law so you can speak. Get that 1820. Don't just type in the chat room, but be a speaker. Let your vocal cords do the work, not your fingers.
You purchased it. You purchased it not by descent. So if your father leaves you something in his will and you take it, you did not inherit it. You purchased it. Legally, you purchased it. You did not inherit. If he did not leave a will and you got his estate, then you inherited it. It fell upon you by descent and distribution.
See? You see the difference? See the difference? All of you think you inheriting your estate, but you're purchasing the estate. The real inheritance comes by way of descent. It's just, what the hell did this come from? Well, in 1703, they said their fourth grandson and granddaughter, press 1, once married or something of this. Right now, press 1, and guess who that is? You, weirdo. Me, I ain't even know. I'm poor. No, we've been looking for you. That type of thing. That's inheritance. That's inheritance.
Otherwise, you purchased your estate. Just that simple. Can't get around it.
Coffee and Kush TV, you on the air? What up?
Talking to, do you remember me? Cocky Turner?
I don't remember you, and it is not time for the call-ins. I'm sorry for your luck.
Page 285. The animus testandi does not depend upon an understanding by the testator that he is making a will. Okay. The Founding Fathers created a trust, okay, and it was complete until after the Civil War.
It was complete until after the Civil War. Oh, the Founding Fathers, it was complete till after all of it. They took it all, family. It was complete till after the Civil War. That's your coup, okay?
Then they start adding amendments.
And then they started doing what? And then they started doing what? So what did you operate before that? You didn't have no amendments. The Civil War wasn't about, it was about them and you, but it wasn't about the way they told you. It was about them over and couping the king, overthrowing the king, and the sovereigns, and the nobles, and the freemen. See? They got you fucked up in time. Not me. Then they started with they started amending. The law was perfect. The law is perfect. The Bill of Rights, the Constitution, the Magna Carta is all just one big part of the same book. You don't take away the Constitution out the Magna Carta and have people believe this is supreme law. No. Because if the bankers took that and making y'all believe you're free and and actually inheriting things. And this was my mama's house, but actually you're just purchasing. And you think the opposite. Lord have mercy.
Now, if there is a trust, there's a possibility that the amendments could be construed as codicils to the will.
See? They X'd you out and brought themselves in. They X'd you out and brought themselves in. Do you see that? Right after the Civil War. Okay? So, did you win the Civil War? Oh, you won that just like you became free in the 13th Amendment, in the 14th. Yeah, right. You lost, and you've been under the control of the right, and who took control of the right the whole time. Oh, no, you've been in an upside-down world living and letting foreigners distribute to you $220 from the county building and stealing your beneficiary package, your inheritance. You're tapping into your trust and playing tax games with your tithes, with God's tithes. Press 1. Legal war. There you go. So you will never be free participating in their entertainment, their Trojan horse, their elephant in the room. No, arguing about what men and women can't do right and why black men and black women and financial abortions, these are all coup d'etat scenarios. Press 1. These are all communist ideals to even have these arguments. They couldn't go to China with this dumb shit. Hell no. China don't allow these people to be on TikTok no damn all day with their heads down like that. That's you. That's you. So they took captive to you after the Great War, what they call Civil War, and they've been here ever since, just orchestrating and playing like they the orchestrators of the wheel when everything they've doing was everything they've done to you is a breach of trust. So they just amending, and fixing and correcting and keeping these cycles, keeping you in a perilous state. That's why I tell y'all that 94 crime bill is nothing more than an amendment. They're just fulfilling their deeds. Oh yeah, they're on drugs that we gave them, that we brought in from Cuba, from Colombia, from Argentina. Oh yeah, so let's send them a beneficiary package. Let's open up a 501(c) of crack rehabilitation called penitentiary. If you get caught one more time, you're going to prison. From 25 to life, and the corrections, and the State Department of Corrections and Rehabilitation. Press 1. It doesn't even make sense. Everything is backward. Man, corrections and rehabilitation, 50 years for this crack which we brought in for you. That's how you do it. Keep them on paperwork. Keep them probation and parole. Keep them not operating legally. Oh yeah, make their lives. Oh yeah, make illegal cool. You see that? Make illegal a culture. You see that? Now bob your head to the illegal culture, where all day in your mind is illegal activity, and we got them. They'll never see it.
Or codicils of a will. It is a trust, and there are such things as wills or trusts with wills attached, or vice versa. Okay, so if we begin to look at the 14th Amendment as a codicil changes the intent of the testator.
You see that? So their amendments changes the intent of the testator, or the person who created it. So this whole time they've just been adjusting and amending what? Well, they've been adjusting. That's why it's called the Adjustment Bureau. They've been adjusting you in time. They've been adjusting and been bending your ass into submission. Oh, my goodness. Oh, my goodness.
Or the trustor, or whoever created it.
There it is.
The 14th Amendment literally did change the intent of this right here.
Of the what? Of the preamble, of the Constitution. We got to get back into that. We got to get back into the original language of the founding fathers and the king. You see, we got to get back to we gotta get the beanstalk and not be cut off. We got to climb the beanstalk once again. Ain't it called Jack and the Beanstalk? I keep telling you.
And they didn't have to know they were making a will, as this little paragraph says. The fact that the testator did not intend the language to operate as a codicil is immaterial on the question whether the instrument is in fact a codicil.
See? And it wasn't even intended. But your intent ain't got nothing to do after the codicil. And then you get the people of nobility and the freemen to deny their past. Oh yeah, they'll be federalized slaves forever. They'll be Confederates forever. You be under the Articles of the Confederacy forever. Press one.
Okay? So now we're going to start looking at the 14th Amendment as the codicil. Page 297 brings up the idea or thought of an instrument of dual character. Okay? Down toward the bottom it says, an instrument in writing may be a contract respecting property in one part and testamentary in another part in relation to other and distinct property. Here we have a definition and description of this estate as compared to the estate that we're going to see the 14th Amendment create.
And that's why I call it the ghost ship. It's dual. But one estate does this and another state cannot.
On page 314, again, section 55 there under wills, it says, property does not pass under a will by any natural right.
Do you see that? Did you hear that?
There go your inherent rights, your vested rights, everything that comes into from the Magna Carta.
You see?
Okay, so if you're a 14th Amendment citizen getting all your rights and privileges under a codicil, you do not have any natural rights.
You see African Americans? You see black man? You see foreigner? Or people of alien descent? Or alien? See? That's why it's important for you to know who you are. Because you have natural right. They want you to believe that you're one of them. You're not. They say you came from we a slave. Not true. You're a freeman. You're above aliens. You're supposed to be operating in a different legal capacity.
Your natural rights reside right here. You've given them all up.
Look.
For the privileges that the government has bestowed upon you.
Boom, for food stamps. Boom. Does that make sense? You're giving them all up for government assistance, and they've taken your inheritance because you believe in the matriarch. Press one. You believe your mama should be the head of household because your daddy didn't do shit. Press one. I don't give a damn if your daddy didn't do nothing. He deserves the head of household. That's why he fucked up. I'm going to get back to it after this, but now you see government assistance. See? It's that easy. Gotcha. Put you in a doc-style situation. Government assistance, they ask.
This is a state law. I didn't make this up. In these pages that you have, when you go through them at your leisure, you'll see that I have encircled or bracketed the footnotes. And a lot of these footnotes have some wonderful things to say or to look up that relate back to the paragraph.
Now I see why I felt that way when I finally said, you know what? I don't give a damn if I don't make another dollar. I'm not doing government assistance no more. Now I see why when I look back, that wasn't just me, Kevin. That was God forcing me. No, this is how they do it right here. Loans after loans after loans.
So study these intensely. Really get into it, because there's more here than what I'm giving you. And even that, what I'm giving you, there is a world more. I couldn't include everything in this lecture. Okay, but I figured this is the bare necessities for you to have and understand, and from here you can branch out. And if you get a letter from the whoever, the FTB, the State Board of Equalization, or the IRS, if you stay focused on your estate instead of them sucking you into the regulations that are established under the 14th Amendment for that particular estate, hopefully you will feel much better. Instead of arguing their argument, you will be arguing yours. At least I find that to be of value. If the testator intended to make an entire disposition of his property in substitution of that made by a prior will, he probably would have proceeded to make a new will rather than a codicil. Okay, so that applies to the Constitution. Second paragraph, while a codicil is a latter will in the broad sense, it is not an independent will, but purports by its form to be an addition to a prior will. Okay, so we're looking at the Constitution now and say, okay, the original form was a prior will. Now we're adding the 14th Amendment as a codicil, changing the intent. Several clauses of the two instruments should, if possible, be harmonized so as to give effect to every portion of each instrument. Now we're separating things, okay? We're separating the two estates. They both have to coincide, truly, okay? Because the 14th Amendment is one state, but it comes from this estate. But in our minds, we have to separate them so that we can tell the difference.
I had to go get my food.
Okay, and in our separation, they still have to mesh perfectly. That's why there is no conflict of law. Okay,
do y'all see how they took it, though? Like, hold up. Let me turn that off. I was listening to it as I went outside. But y'all can see that it's all built off of debt. They offer you one thing, but it's really war. It's like olives and arrows. You got it? So you're dealing with, oh, we'll help you out. But I want you to know this is all a loan and out of your trust. So you're the debt bearer of your own trust that you think we're helping you out with because we got you filling out all this paperwork. You see, it's not help. It's debt. It's debt bondage. Food stamps and government assistance, you know what they're paying you back with? The ability to get abortions. Yeah. Your ability to have state-funded and federally funded abortions is war. Don't you get it? That's why Fauci's doing those tests. Keeps the 5013Cs rolling. So your woman liberation empowerment is an act of war. So who's pushing these ideals on you? TikTok, YouTube, social media. And then it becomes social engineering. Then your mind becomes communist. And where you got your beautiful black queens out here saying, yeah, I can have abortion anytime I want to. You see? That's exactly what they want from you. They don't need the man head of household to destroy you. They just wave dollar bills in front of her and call it independence. And we'll use that as as the fuel for the matriarch system, which is all international banking and international banking corporations. Use that as a 501c. We keep her in church, singing and dancing, and him unaware of the law. You got it? It's easy. And you got a black slave forever. Anybody kicking no shit like me? Kev Rowe.
Their estate and our estate are in complete agreement. Should be. On the next page, 651, section 532, where codicil is clearly inconsistent with will, where it is found that a will and the codicil thereto contain repugnant bequests of the two bequests, the one contains...
You know you listening to how and understanding how they stole your legacy? Oh, that's a blessing, ain't it?
...contained in the codicil shall stand.
And now you see why they hugged the Constitution and the American wartime flag with the fringe around it. Ain't it a blessing for it all to make sense? And how the United Nations have King George's or George Washington's flag. They have your sovereignty, and you have their flag. You're actually raising the flag of a destroyed, of a conquering nation. Incredible, right? Huh?
That's nauseating, isn't it? A codicil plainly inconsistent with provisions of the will operates to the extent of the inconsistency as a revocation of the will, even in the absence of any expressed words of revocation.
Think about it. They have George Washington flag. They're on your land and call themselves the United Nations. And they're tapping into your trust. They're all at the table here and at war with each other there. Now that don't make sense, dude. That don't fucking ring a bell to you. Huh? All of them got federally approved and you got a PPP loan scam. 2 strikes on your account. You claim about to get F-16s and all type of shit. And you got food stamps. You ain't even thought about it, y'all.
Page 663, and this is where it's going to start becoming important to you, okay, to understand that the 14th Amendment as a codicil and what you have done.
What we have done, and what happened to the 13th Amendment citizens. Oh, they were genocided. Exodus. They was taken into captivity. Press 1. Damn.
Section 1607, the doctrine of election. The doctrine of election in connection with testamentary instruments is the principle that one who is given a benefit under a will must choose between accepting such benefit and asserting some other claim he has against the testator's estate or against the property disposed by the will. One who elects to accept a benefit extended to him by a will is bound to give effect to all the provisions of the instrument and perform the burdens imposed upon him therein, including the renunciation of any inconsistent rights or claims. Yes, elections. We look at the 14th Amendment.
This is all a part of the game. Taking part. It's all a part of your destruction.
Amendment.
Shit.
As a codicil, we have all made elections to take under the codicil or take under the will.
AKA meaning to help the system crush the people who are originally before us, who have their will. We can't exist without doing this shit. We wouldn't even be. This shit is like so blasphemous, wrong, and backward. It's like, damn, but it's history. So why not? You know.
Okay. Oops. I lost my thing.
You lost that a long time ago.
Okay. Be nice.
That'll be edited.
Okay, let's go to page 677. About 677, section 1622. Manner and form of election, what constitutes? The question of the manner and form in which an election to take under or against a will must be made, or as it is sometimes phrased, of what constitutes such an election, is influenced to some extent by the applicability or inapplicability of a governing statute relating the particular kind of election election in question. If the election is one governed by statutory provisions relating to the manner or form in which it is to be made, the effect of such provisions must, of course, be considered. In the absence of an applicable statute, however, the view is generally taken that a testamentary election may be expressed or may be implied from the acts or conduct of the beneficiary on whom the election devolves. Second paragraph, there can be, it has been, excuse me guys, I don't mean to be this way. There can, it has been said, be no partial election to take against a will, but the election, when made, must be complete and final. This is saying that you cannot ride the fence. You can't use that Social Security number and have this.
You can't want to be no king and queen and be scared to be self-sufficient. You can't think you better than the next nigga or woman. There's some deep shit. You can't think none of that shit. Can't be of materialistic mind. You can't be in a debtor's position and then take after sovereignty. You make a choice. You want to be free or you want to be a slave. You want to be free or you like your current situation. Like there's no, oh, I'm a queen on food stamps. That's not logical. I'm a queen, but I'm in debt. I'm a queen, but I am in total opposition of God. But I'm independent. I do what I want to. I'm looking for a man just to help me. Press 1, do what I want to. Because I'm the head of household. A woman is supposed to know this and place her man as the head of household. Even if the man you chose is the bungalow 54 type of nigga. It is important. Press 1. You hurry up and go get one. But no, I'm just making fun of our, of course, situation. But this is what you're dealing with here. There's no straddling the fence.
You can't have that bank account and have this, at least not at this time. You can't have all those wonderful benefits that are given to you by law and have this. Just can't do it. There's no riding the fence.
You either begin to know and exercise your right, or you lose it. There's no in between.
At this time. That's sad but true. Sad but true. Page 679. With respect to elections arising from matters in pays or implied from the acts or conduct of the beneficiary, it may be said that two things are necessary in order that the acts relied upon will amount to an election. Number one, the person alleged to have made an election must have been cognizant of his rights.
This is so funny. Mm-hmm.
I'm sorry, I don't mean to laugh. That is, he must have knowledge not only of the condition and event of the testator's estate, but also extent of the testator's estate, but also of his duty to elect between the two inconsistent rights. I don't believe anybody's ever informed me of that. Of course, they always tell me I made an election. And to having knowledge of his rights, he must have intended, as shown by clear and unequivocal acts, to make a choice. Haven't you done that? Mm-hmm. You've all done that. By your acts, you have seemed to made a clear choice. By your own acts.
That's important for you to know. You're going Democrat or Republican. Make a clear choice. Doesn't matter what choice you make. All of it is in participation of what? Okay?
Of course, you weren't told your rights. You weren't disclosed anything about the estate. In order that the beneficiary's ignorance of his rights may avoid what otherwise could constitute a conclusive election, however, it must not have been culpable on the part of the beneficiary, and the misapprehension must be clearly shown. Okay, if you haven't been informed of your rights and you have had non-disclosures, you better start telling them about that, because your election really is no election. Okay, you might have made an election as it appears to them, but they did non-disclose to you. As a matter of fact, I don't believe I recall my civics class teaching me about this estate. And in my history class, I don't recall hearing about it either. Of course, I always heard that the government agents and the bureaucrats were, trustees or in their fiduciary capacity. You know, we've all heard that. Of course, they didn't explain that to me. And as an heir, I believe I have the right to know what they mean by their little words. They are trustees. Page 681. Section 1626, acceptance of money or property. In a large number of cases, the principle is is recognized, stated, or applied that a showing that the beneficiary faced with an election for or against a will has accepted, used, enjoyed, or entered upon, or remained in the possession of money. Yes, like Federal Reserve notes. Property. Or some other benefit, like unemployment, extended him by the will, tends to establish an election in favor of the will. The rule is, of course, subject to the qualification that acceptance of a benefit under a will, when made in ignorance of the beneficiary's rights, or under a misapprehension as to the condition of the testator's estate, such as bankruptcy, or other pertinent factual considerations, does not operate to constitute an election. Hallelujah, hallelujah. Okay. Did you notice there? It said ignorance of your rights. Remember that little comment that ignorance of the law is no excuse? Well, ignorance of your rights is no election. How do you like those apples? I thought that was good. I like that. Moreover, the principle is subject to the further limitation that where the money or property was received or accepted in some other capacity than that of a testamentary beneficiary, well, maybe it's not. Maybe we're not testamentary beneficiaries. Maybe we're heirs. Okay? Or amounted to no more than what the beneficiary would have been entitled to, independently of the will. Such receipt or acceptance does not.
Let me say how silly these people look. Ain't these people all Brits and white people? Wouldn't you think, since they're pilgrims, they would be knowledgeable that they're free people by way of the king? Why wouldn't they know that they're heirs? Why wouldn't they know? Because they told you a motherfucking story that kings and the King George and they fought for your slavery from him. There will be no need. There will be no fucking need to do that. For you not to know you're heir. You'd have been taught your children you were heirs, unless you know that just a few grandmas ago you were over in Russia, in Germany. Okay? How wouldn't you know that? Now, you can't be kings and queens and New England patriots. Press 1. You can't be patriots and monarchists. You can't be freeman and goddamn citizen. There's no such thing of a sovereign citizen. We thought it was, but it sounded cool. There's no way. The terms alone conflict each other.
Indicate the making of a binding election in favor of the will. We're entitled to it to begin with.
As heirs.
As heirs, we are entitled to it. Those people who are taking under the will, who don't want to be heirs, but want to be beneficiaries of a different estate in order to be taken care of.
That will be you.
Because they're not capable of taking care of themselves and
that'd be you.
Be independent, they may do so.
See?
I'm not going to stop them. I just want my freedom. I want my inheritance. I want my estate. That which was guaranteed to me.
Ma'am, you would have your estate, remember? Your name go all the way back to the founding fathers, remember? Them your people under the ground with all them beautiful white European London names, British names, right? English, right? Wrong. And they know it.
Next page, you'll see some footnotes that are bracketed. Take a chance to read, or time to read those when you have a chance. Okay, section 1630, initiation or maintenance of judicial or administrative proceedings. Okay, while there is a general agreement that the unsuccessful assertion, and we've had plenty of them, in a judicial or administrative proceeding of a claim under or against the will does not amount to a conclusive election for or against it, the theory being that where such a claim is proved groundless, it is conclusively shown that the beneficiary was not in possession of two inconsistent rights. Oh, we're commingling. And hence was under no duty to make an election. There is no doubt that prosecution of or intervention in the judicial or administrative proceedings will, under many circumstances, be regarded as constituting an election to accept or renounce the provisions of a will. Okay, so what if you use the district court? Now you go, well, what does that mean? Okay, well, the district court is a tribunal established under the inferior estate of the 14th Amendment. And just because...
Did you hear that? Motherfucking district court, nigga, is established under the code of seal of the 14th Amendment. All of these are fucking minor estates. Don't you get it? All of them. All the courts, it's all up under the same shit. Lord have mercy. That is that's a beautiful.
Because you've gone there doesn't constitute an election. Page 687, section 1634. As a general rule, an unconditional voluntary election to take under or against a will made with knowledge of the facts and of the rights of the person compelled to elect, and not induced by fraud or undue influence, may not be revoked or set aside.
I was told I had to get a Social Security number in order to work.
I believe that you've had a little bit of non-disclosure to. Well, they're presuming that you are party to an inferior estate, one created for your benefit, because it is presumed that you are incompetent.
Did you hear that? You are presumed to be incompetent. You got to be incompetent if you black under law. That means you retarded. You got to be retarded because you don't understand that black is dead. So you said you a dead man walking, or you a zombie? Oh yeah, you need help. Put this helmet on and these Balenciagas.
Okay, next page, 1636. The prevailing rule is that an election to take under or against a will may be revoked or set aside where it was made through ignorance or mistake as to material facts affecting the rights of the party electing, and where the rights of the innocent third party will not be adversely affected by the revocation. I wonder who that might be. The revocability absent intervening rights of innocent third persons, the elections procured through fraud or undue influence, or of elections followed by the failure of the provision made in the will for the electing party, or the non-performance of a condition upon the election was made, has been widely recognized. I believe there's a condition. All of this applies. It all applies. Okay? When we have to look at the 14th Amendment as a codicil. Next page, section 1639. In this paragraph, you are told that if by some slight chance, or even a big chance, you have taken property under the will, you have to return it in good faith.
If you've taken property under the will, that's everybody under the codicil. You have to return it in good faith. And it's damn near because Jesus said so. That's why. If you've taken something that's not yours, you have to return it. Press 1. This is what your teachings of Jesus is all about. This is what the Bible talks about. And this is what it's about. You gonna come down and go down there to the valley of Jehoshaphat where the Lord will plead with you. The Lord will plead with you by legal matter. Are you going to be able in good faith to return what was taken? And you know you've taken under the 14th Amendment. You see what I'm saying? You see how this works? You see how God deals with the man before the scourging, before the ass whooping. Before the ass whooping. Press 1. In legal matters.
You got to return it. You have to offer to return it.
You got to say, look, what Tupac song say, everything they owe, you have to make a gesture of return. See, but they can't do it. But you got to understand what they got to be able to do so you know it's not you. You just repent in your disobedience of God and turning away and finding a way back to Him. So you will take part in the kingdom of God and not be a heathen or those who are rejected. This is how this go. The prayer that Jesus told you to pray was the prayer of God's kingdom here on earth. Not that you finna get some angel wings and fly outer space. Who told you this?
Proper to make a good faith offer to return it. This isn't everything. Okay, now we go section 1647 on page 700. The broad principle that one who receives a benefit, and Social Security is a benefit, so is unemployment, so are your school.
So think of it. How did they get Social Security benefits from Ukrainians and people of foreign nations who have put nothing inside of Social Security? You tell me. And what trust are they tapping into? And is it legal?
When you read the statute of charitable uses, you will find what your benefits are. I mean, it's schools, it's military, it's highways, it's everything. All these things are benefits, okay? And all these things are received under the 14th Amendment of State. The broad principle that one who receives a benefit under a will by which the testator attempts to dispose of property which belongs to the beneficiary, or in which the latter has some right, claim, or interest, must, whether or not the testator was aware of his own lack of complete ownership, elect between his right to accept the provisions in the will in his favor and his right to assert his independent paramount title. We're now asserting our independent paramount titles, which is recognized in many decisions, has received actual application in a wide variety of factual situations. Prominent among these may be mentioned the situation existing where a testamentary beneficiary is the obligee in an alleged contract of the testator to devise or bequeath property, where a device or legatee is also named as beneficiary.
All dealing with how they're supposed to be acting towards you. They're supposed to be nearly, I ain't even gonna lie to you, bowing down at what you've given them.
We can stop there. Contract, contract, is this bringing in some commercial UCC stuff? Contract? Did we enter into a contract in the 14th Amendment to receive benefits? Now, there might be a possibility there, yes.
Now, do you hear that? Did you to receive benefits? It's amazing when you find out, when you sit back and listen to old people talk, right? You sit back and listen to them. It's amazing what you find out. Because they know they got a whole beneficiary package. You got the ass end of the stick. You got robbed. But this is history.
I think so. Yes. So therefore we become an obligee. Now we have a possibility of the UCC coming in, so we keep that right here. 1657. Estoppel. Estoppel means you are stopped. You are barred. Now that means a little bit more than that, but just...
Which one?
Section 1657, page 712. Okay, here's where we're bringing in the bar to us getting to the estate. The broad doctrine that one who accepts benefits under a will is subject to certain exceptions and qualifications. Estoppel, to attack its validity and binding effect, is frequently recognized. You go into and you start talking about your rights and etc. under the 14th Amendment. You are estopped. You can't get to your rights. You have no rights. They are privileges. Your rights reside in the preamble. Okay, you have created an estoppel by taking under the will.
Meaning you can't get to the Supreme Court or to the Supreme level because You're barred and you know nothing of law and you've taken after the codicil, my free noble. You got it? And you can't get out of that.
Well, the light went on.
Oh, did we have a light bulb go on? Oh my God! Have any of you had light bulbs go on? Any of you have a like a flashlight going? Wow, I hope so. I hope so. That's what this is here for. Okay, claim acceptance of money. Okay, what am I going to read here? The view is sometimes taken, for example, that an election to take under a will once made itself operates as an estoppel. Okay, again, estoppel. You elected under the Social Security. No wonder you can't get rid of your Social Security. Okay, all those little revocations and letters to the Social Security Department, and the Social Security Department's going, hey, no, man, this is your Social Security number. You can do anything you want, And you try to get rid of that Social Security number, and you feel like you can't, but, you keep trying. Well, you're stopped. You took under the will. But then, of course, we haven't attacked in this angle before. Okay, when I recently sent a nice little letter to the Social Security Department informing them of their restraint on alienation, bringing up trusts in the states. And I don't think anybody has discussed this with them before. So we're going to try a new angle here. And we're going to keep trying to get new angles until everybody understands what's going on in this country. Then we won't have to use any angles because we will have our power back. The United States, the people of the United States, the voting citizenry, are getting so angry that they're all claiming that they're going to get their country back. They have no country to get back.
See? You have nothing.
Have no inherent rights. I'm sorry. It's that simple.
So everybody's saying, God bless America. Candace Owens and them. All mouthpieces for the oil tycoons and insurance companies. And there is no freedom to get back because you all taken under the 14th Amendment Codicil. So you're dealing with privileges, what you're allowed to do and what you're not allowed to do. See, the police are allowed to shoot you and stop black people because most people think black people are bad. So just pull them over, beat them out the car. And you know what I'm saying? These types of things.
It's sad but true. Let's continue on. We're getting out of wills, and now we're going to go to descent and distribution, which is found in Amjur 2, or I found in Amjur 2D, 23, or 23 Amjur 2D. Section 2, it's page 756. Descent and distribution, section 2, second paragraph. In its strict technical sense, the word inherit means to take as an heir, at law, by descent. Within this meaning, personal property is not inheritable. Oh, there's a hole there. One who takes under a will does not inherit.
And thus making manifest destiny illegal. Press 1. That was a total act of war. Manifest destiny is illegal. Self-admitted. No plausible deniability. It's illegal. Especially on this homeland. They are crazy. And this is what you're not supposed to wake up to, is that everything that they did in your history was illegal. And you're going to wake up to that. And that's a shame. No, that's crazy. Everything that they've done in these amendments, in these policy jailers, is illegal. And the only thing that makes it legal is the fact that you're asleep and is participating in the illegal, in the trust being neglected.
You take under the 14th Amendment. You do not inherit. This is an inherent right. It says so right here under estates, wills. They all fall together. Here we have something about vested at birth. We have to get to understand what vested rights, inherent rights, inherited rights, these all come together. The United States people as a conglomerate have no inherent rights. They have no vested rights. Well, they have vested rights under the 14th Amendment, but no vested rights here.
Because they're not allowed to own anything. You have privileges by way of the federal government and the trustees, but you have no right. That's reserved for the freemen and the nobles and the beneficiaries of the king.
And well, we have to keep this very perfectly clear. Let's find the next beautiful paragraph. Now, you have to also remember, too, that the 14th Amendment was never legally ratified because the 11 southern states were kicked out of their legislators and replaced with military leaders. So,
does that make sense? Huh? It's because the 13 what? Sound like the 13 colonies what? And was replaced with what? It's dealing with 1898 and the coup d'etat that happened in the South, where the federal government allowed press one. See, if you don't know your history, you wouldn't know how all those pictures of you hanging everywhere came about. The federal government deputized foreigners and they overthrew you. They all deputized and there was a whole army and they just ran you guys out of towns in the South, destroyed all of y'all governors and people who were in power at the time. Yeah, this how Tulsa and all of these stories came about of back in the day of these acts of violence towards these black towns. This is it. Right there. Martial law. There you go. And you've been in that ever since the overthrow. Why you keep thinking I'm mentioning 1898 in Wilmington and the Articles of Confederacy and these nations? They will never be ruled by you people again, by the patriarchs again. It'll never happen. And that's what they vow to do. This is a part of history, which is illegal. Another legal matter. Aha. But you're barred, remember?
So that nullified the Constitution at that point, and everything since then is obliterated. It is not law.
And everything since there is obliterated and not law.
It might be law for an inferior state, but not for us.
It may be law for an inferior state. They claim we inferior. Remember Tupac? So what's the inferior state? You became the inferior state. So she's playing all roles at this time. But you're the inferior. It may be lawful to you. They may be able to do those things to those people over there, but not. But turns out those people over there, those people over there are the heirs.
Actually, I guess we have no law. Oh, let's go to the sideways page. When I write now, I don't call myself a state citizen because I don't like that word anymore. When I look at the 14th Amendment and I know that the United States government has the authority to do whatever it wants in its corporate capacity to property that has been owned or is owned to and ceded to them or granted to them, I look at the 14th Amendment and I say, this looks like a grant to me. It looks like property ceded to me. As much as I don't like the idea that sovereign state citizenship has been ceded to the United States government, it may be a possibility. And if it is a possibility, what do I have left to discuss with them about where my rights come from? Well, I have my estate, and I also have the idea that I am an heir of freedom, as the founding fathers were. That's what they claimed themselves to be. They didn't claim themselves to be sovereign citizens. They didn't exist. The Crown gave that to us. So if sovereign state citizenship has been ceded to the United States, such as what we find under the Buck Act, okay, totally different subject, but it's also an interesting theory that the state has been ceded to the federal government. So now what do I discuss? Well, I discuss my heirness. You can call it, I am an heir, okay? And
Again, the only airness you know is Michael Jordan and Nike Air. Your airness.
on this page here, I call myself an heiress astrarius, which is a common law word. And let's see if we can find it. Okay, down here there's 2 stars on the left, and it starts out with Coke shows. Okay. Coke shows the heir apparent may also be complete heir. That's me. And have use and profits of the estate. Yes, that's me. That's definitely me. He is termed the heiress astrarius.
He, ma'am. He, not crazy white woman. He, ma'am. He.
And he takes by descent. For if he took by purchase, he would be subject to relief. And I am definitely not subject to relief. I have no relief, so I must be the heiress astrarius. So therefore, I now sign my name, comma, sui juris heiress astrarius, because I'm also of age and I am competent.
And that, ladies and gentlemen, is how you are complicit in theft. Identity theft. You see? She just want to be anything that she can be. That comes from an immigrant mindset. Anything. Now, you wouldn't expect that from her. You just change her status to an heiress now. It don't say nothing about her, she, nothing. Nothing. He is very adamant about he.
And this is the dawning of the age of Astrarius. This is, yes. Okay. I think they've already done that, except they really messed up the wording, so they probably couldn't read when they wrote the song or sang the song. Okay, now so far we have gone through the most important thing to understanding the preamble. Okay, the estates, the covenants, the things, and like I said, in your leisure, I mean, right here, I've just skimmed over this right here. You have plenty of material to read from what I have just given you, and there's more of it. Okay, now we're going to go into trusts, okay, because we're going to segue from our state over to the inferior estate.
Okay? Now I'm telling you, they know what they're doing. They're going from the sovereign estate to the inferior estate, which would be the citizens under the 14th. Now they don't want to be, but they dump the nothing estate on you. So she's really talking in code, but the inferior estate is those who lost their initial estate. You got it? So she don't want to say the niggas over there, those blacks, but it's the inferior would be a correct term because you're dealing with Nazi.
Okay, everything I read will still apply to this, but now we're going to start swinging over here to the 14th Amendment, and we're going to look at a different estate.
And we're going to go right into that because why prolong it? We're going to go into part 3 and probably play part 4 tomorrow. I mean, why stop? I mean, we were off for a couple days. Why stop?
Everything has been commingled up to now. Okay, the first we're going, oh, this is a marvelous book. It's called The Law of Trusts and Trustees. It is by two Bogarts. I don't see. Is one alive?
Yeah.
One is still alive. Oh my God, that's wonderful. Well, the original must be his son, I guess.
They're brothers.
Brothers. I presume that they were sons. The original was written in 1931. Perfect timing. They had a lot of world of worth of information there. And it's basically upon normal, average, ordinary trusts. And every now and then they throw something in regarding history, government, etc. Okay, on page 4, section 1, they name the trust parties. Okay, there is a settler of a trust, and he is the person who intentionally causes it to come into existence. There we have the founding fathers.
Would be a settler of the trust because it was settlers who held the charter. Of course. They're called settlers, remember?
Okay. The trustee is the person who holds the property for the benefit of another. Okay. It's the government's duty to take care of our property for our benefit. The beneficiary or Sestwike trust is the person for whose benefit the trust property is held by the trustee. That's us. Well, I don't like to call that us. I like to call us the heir, because I don't want any confusion between their 14th Amendment beneficiary and me. So I'm an heir, because this shows that there are heirs in here. Posterity is an heir. We go into the trusts and trust rights and duties, okay, and he defines for the benefit of the Sestwi, and Sestwike trust means beneficiary. And it goes into the duties of the trustees.
Where is this?
Oh, this is on page 6. This is superficial stuff that we're going through temporarily, okay? He goes into the classification of trusts, okay? On page 7, trusts are usually classified into two main groups, express trusts or implied trusts. We really don't want to get into the quagmire of federal law. Because it's just like quicksand. Quagmire. It's like quicksand. On page 264, remember we discussed the Catholic Church. Section 37, Religious Corporation Soul. Some slight remnants of the doctrine of corporation soul still exist in American law. In the English law, the king, certain church officials, and other occupants of public positions were treated as having a separate entity as officials and were called corporations sole.
This is where the straw man comes in. You got it? So they didn't do nothing but hijack what was already in place. From the corporation soul. You know what selling your soul is, right? Kanye West selling his name, he sold his soul. But that's, I don't want you to take that in a religious way. He sold the corporation of himself. You see that? Okay then.
The king, the sovereign. Could it possibly be that our corporate capacity of the United States government is a corporation sole?
Mm-hmm.
Yeah. There's so much in Bogart that I have to search for it. I bought these books for $1 a piece. Let's buy that, and I thought I had a complete set, but number 4 was missing. So I think I paid $5 or $6 for the whole set of Bogart's Trust, and it sat on my shelves for almost 2 years. And I was about ready to give them away, going, wow, I don't know why I'd ever used them. I wasn't interested in trusts, at least I didn't think so, until I found this, and then Bogart came up with some wonderful things. Okay, next page, 546. Oh, selection of trustee who cannot be sued. Let's go down to the marked line. It says, neither the Crown in England, the United States, nor a state can be sued without its consent. What? Now we have the trustees. Now I can show you that they're trustees. Okay, they bring in the words United States, Crown of England, a trustee who cannot be sued. Okay, and the United States claims that they cannot be sued unless they give their consent. Well, that's kind of, you can read that later. California statute preventing. Oh, here's over on the right-hand corner, bottom 547. A California statute prohibiting gifts by will to the United States among other corporations is not unconstitutional on the ground that it permits gifts to the state of California and its subdivisions, U.S. versus Bernison, 1950. Here we have a mention of the United States in its corporate capacity. Okay, so when, the question in my mind comes up quite often is just when did they start using their corporate capacity, because they weren't always a corporation. They didn't start out that way. The words don't say in God we incorporate. The words say in God we trust. Okay? So when do they start exercising their corporate capacity, and is it a de facto corporation or a de jure corporation? In the state of California, in most states, you cannot be a de facto corporation. I don't see evidence that they are de jure either, except for this grant right here. Page 556 is on reservations. It is common that the settler is himself a trustee, either by his own declaration or that fact, or by reason of a conveyance by himself to himself and others as trustees, or by buying land in his name as trustee for another. If the settler reserves no powers to himself expressly in the trust instrument, he will, as settler, have only sentimental interest in the administration of the trust. That is why there is a reservation in the Fifth Amendment and reserved to the people, so that there is no sentimental interest. The reservation, remember, is important. I told you before, it had to have a reservation. Isn't this beginning to look beautiful? Got to keep those reservations. Everything falls into line under these estate laws. And hence his position as trustee does not, in the usual case, give him a dignity of legal interest. Duality? Thank you. Duality, yeah, my eyes are getting a little tired from reading. Page 557. Municipal corporations as trustees, in that it goes into the towns, cities, villages, school districts, and other governmental agencies are created by the state. Okay? Down at the bottom when you see little mark where I say cypress, cypre, okay? We're going to get into cypre. It's important. Are we missing a page? No, I guess not. Okay, we're going to go back here. Cypre, I'll see if I can. If such power is lacking, there will be vacancy in the trusteeship, and the court will appoint a trustee. This is cypre, okay? But the validity of the instrument of creation will not be questioned, okay? I know it's vague so far. In the groups of governmental, eleemosynary, or educational charitable trusts is on the next page. Got to find where we can clarify this. A municipal corporation has no power to accept and carry on a private trust or a charitable trust for religious purposes. You know, this is added quickly, for religious purposes. It didn't say or charitable trust, period. It says charitable trust for religious purposes. The 14th Amendment is a charitable trust. It establishes a... Mm-hmm.
That's why everything's in a private corporation. Social Security.
Yeah, well, okay, the way I see it is the Federal Reserve Act created the trust fund, okay? It established the trust fund. It actually did establish even maybe a lesser estate than the 14th Amendment, a non-freehold estate. The Social Security Act itself created possibilities for beneficiaries to draw from the trust fund. That's where you separate the gold and silver from the Federal Reserve note. Now you're a beneficiary over here under your main principles, collecting money that is for the beneficiaries of a 14th Amendment estate and trust. So we're going to get into this further. I want to find cypre when I can. I wish I hadn't brought that up so soon. On page 560. In the early law, the position was taken that a corporation could not hold to uses or be a trustee on account of its impersonal, artificial character. It had no conscience. Equity could not act on it by a decree strictly in personam. This objection was overcome as early as the middle of the 18th century. This is when they started to attack the mortmain statutes. Okay? In modern times, corporate trustees are probably more common than individual trustees. And the trust company, the professional corporate trustee, assumes an ever larger position in trust management. Boy, it sure has. It is obvious that the charter or incorporation papers of a corporation, considered in the light of the statutes and constitution of the state, will determine the capacity of a corporation to administer as trust. Let's turn pages. Let's go on. The Law of Trustees and Trust by Bogert, again, Volume 2. Now we get into federal income tax, duty to make a return.
Where is it? 143?
143. Section 264. Trustees are under a duty to make a return of income of the trust if its net income was $100 a year or over, or its gross income $600 a year or more, if the beneficiary is a non-resident alien. Footnote 39. Please go down to footnote 39, letter C. Do you see on the side there where I have written? This was valid in 1910. Any fiduciary required to make a return under this chapter shall be subject to all the provisions of law which apply to individuals. What law applied to individuals in 1910 with the duty to make a return? When was the 16th so-called amendment passed?
1913.
No, 1914, wasn't it?
It was after 1910.
Ah. No, you're right. So it was 1913. Yeah.
Well, it never was ratified, but supposedly 19.
Well, even if it was or if it wasn't, here we're discussing that individuals are supposed to have made a return prior to the supposed enactment of an individual income tax return.
Corporations.
This was for trusts. What they did was they created the laws that were going to apply to us before they applied it to us, and they applied it to the trusts that were in existence. They attacked the existing trust at that time in order to break them down so that it could eventually come around and be applied to us under what they've already established.
Devious.
Ah, the plot thickens. Yes. We go on. Okay, returns. If the return is made on the basis of the calendar year, it must be made by April 15th. The laws were already established before they created them toward us. Wasn't that generous of them? Here down here it says, if he makes oath that he has sufficient knowledge to the affairs of the trust to enable him to make the return, and that the return is correct to the best of his knowledge and belief. Here we have your statement of perjury. Now, trusts were attacked in court openly from what I gather from about 1893 to about 1925, even further on. They were attacked in order to destroy the integrity of our trust, to chip away at the building blocks, the foundation of this country, to get through to this. Now on page 164, I don't know if any of you have ever received letters from the Internal Revenue Service or the Social Security Department saying that something about a right to receive. If you probably would skim right over it, okay? Everything's all about a right to receive. When they use the words right to receive, there is a trust involved. And on 164, there's a little line there is talking about the beneficiary has a right to receive. And so does page 165. If you ever see that wording in a letter that you receive, they just informed you of a trust. They just informed you. They didn't use the word, but they just informed you. That's how they inform you deviously, okay? Under the table, underhand. Now, according to Bogert, on page 216, it starts, there was a case in 1925, Frick v. Commonwealth of Pennsylvania, and says, in the decision in Frick v. Pennsylvania, it put an end to all this and placed property taxes and inheritance taxes on essentially the same basis, so far as the power to tax with reference to chattels were concerned. Now, I've read this court case, and I can't find it, but I believe truly that this man knows exactly what he talks about, and that inheritance taxes and property taxes were placed on the same basis and same level. Like I said, I've read the case, and I keep scratching my head going, now, how did they figure that one out? Obviously, it's got to be in there somehow and somewhere.
Probably the wording. Some wording.
Oh, I'm pretty good at figuring out wording. But have you read it? You haven't read it? I've read it. And I take this man's word for it, because this gentleman or these gentlemen knew a tremendous amount, and they gave a tremendous amount of information on trust, and they evidently saw it. I believe it's there. I just haven't figured out exactly how it's worded in the Frick case to have property taxes and inheritance taxes placed on the same, essentially on the same basis. Okay, so now here we have the income tax and presumably the inheritance tax going like this. We're now on the same basis. So this is how they brought all the trust stuff into our supposed income tax. Okay, do we get it? The couple paragraphs down, as will be shown later, the estates of aliens and non-resident citizens are to some extent subject to the federal estate tax. Some extent. We're still on the same page, 217. Okay, the last paragraph. The estates of aliens and non-resident citizens are to some extent subject to the federal estate tax. Now, what if you were a non-resident alien in this country? A lot of people are attempting to use the non-resident alien argument. And, it's, are you really a non-resident alien? Are you, what the heck are we? Are we really sovereign citizens? Are we heirs? I'm an heir. But a lot of people are using the non-resident alien argument, and it may or may not be exactly what they think it is, because I have found different wording or a different way of writing or saying non-resident alien. And I don't think it means non-resident alien, but then I may be wrong. We'll be reading that shortly. I'll let you determine exactly what it means. News at 11. Gift tax, page 306. The federal gift tax was incorporated into the Revenue Act of 1924, but was eliminated in the revision of 1926. For 6 years, there was no such federal tax. But in 1932, this feature of the tax statute was reinstated, and it is to be found in the present statute in detail and elaborate form, having been amended from time to time between 1932 and 1951. Well, my gosh, they took it out for 6 years, from 1924 to 1932. This must be important. Okay, the gift tax stuff. Why would they have taken the gift tax stuff out for 6 years and then put it back in around about the time the Social Security Act came in? Does that seem to make a question arise in your mind? Gift tax taken out for 6 years? If it's an estate, if this is an estate, and the 14th Amendment creates an estate, what is the income tax? Down at the bottom, let's see. The statute applies to gifts of property of all kinds, whether the gift is by trust or otherwise, and is direct or indirect. If the transfer is a citizen or resident alien, the Act applies to transfers of any of his property. But if he is a non-resident alien, it governs only as to property situated within the United States. A couple bells go off? A bell go off? Any bell go off?
Try to be dinging.
A little ding, just a little ding? Did you catch a little word such as the words situated within the United States? Ever hear that before? The tax is not imposed on the recipient of the property by the donee. On the contrary, the tax is primary and personal. Liability of the donor is an excise upon his act of making the transfer. is measured by the value of the property passing from the donor. Any more bells go off? Of charitable trust. Now we're going to go into charitable trusts, folks. Okay, we just touched upon taxation as found under trusts. Okay, and it's bringing out little bells and little catch things, that keep getting your attention. Like, oh, what was that? Did you see that shadow flick by? Was it something truly there? Okay, we want to find out if these little shadows flicking by us are in our imagination or if they actually exist.
Can't wait to see when it says voluntary compliance. Somewhere.
Oh, it's voluntary.
Yeah.
Sure. Oh, it's voluntary. You volunteer to take under the will.
Yeah.
You made that election with voluntarily. Now, charitable trusts. Let's see. The preamble of the statute. We're on page 418 of Bogart's. The preamble of the statute of charitable uses gave illustrations of current charitable trust, but was not intended to set forth an exhaustive list of trust. Going further on, showing the kinds of objects in which the 17th century were regarded as social benefit, but surely could not reasonably be considered as a measure of 20th century social policies or purposes. Do you want to bet? Do you want to bet? Let's see. Oh, by the way, just to go off side, that the statute of uses, not charitable uses, I don't know about it, but the statute of uses in England was repealed in 1925. Great timing. Them and us. 1925 was repealed. This is a statute of 43 Elizabeth C4, made in 1601. Okay, now this is a long time before the Revolution in our country. Here the founding fathers were, fighting for the Magna Carta. Now the Magna Carta was written in 1215. Here they were fighting for the Magna Carta in 1775, 1774, 200 odd years. Okay, here we are now 200 odd years again away, fighting for the same thing that they fought for 200 years ago, or wanting to fight. Not even pre-revolutionary war, if there's going to be one. Hopefully, it would be nice to have a civil understanding between the government and ourselves. But the jumps were, they did not forget the Magna Carta. And now I am not forgetting the Magna Carta, nor am I forgetting the estate and the preamble. So time comes down to just the argument just happened yesterday, as far as I'm concerned, with the founding fathers and the Magna Carta in 1215. Everything was just like it was yesterday. To me, I've reduced time to a very short period of time. But the statute of uses, again, or the statute of charitable uses, relief of aged, isn't that Social Security? Do we say, okay, the relief of aged, impotent, and poor people, that is definitely, absolutely Social Security. Okay, if you can relate to something and it starts looking like it, it must be it. As far as I'm concerned, the statute of charitable uses is the English Social Security, form of Social Security. There may be a section somewhere around here where it shows that taxes in England are for charitable uses. Yes.
One of the other areas.
Did you happen to see it?
Yeah.
Okay, it's for houses of corrections. Okay, tradesmen. Here we could have employment. The redemption of prisoners. Here we have our prisons. The ease of any poor inhabitant. Here we have all our socialized benefits. Our socialism. Okay, it comes from the statute of uses. So here we can look at the 14th Amendment and say it must involve a charitable use, a charitable trust. Mm-hmm. Yes, it does. Okay, let's pass on. Okay, if we look at the 14th Amendment, is beginning to look like a charitable trust. It is. Now on page 451 we go into Mortmain. The English Mortmain and Charitable Uses Act. Oh my God, they just right in together. There's a little marked section in the footnote of that. It says a charitable trust may be created by will by the incorporation by reference into the will of the resolution, declaration, or trust agreement executed by a community trust if such instrument is recorded in the office of the Secretary of State. Okay, whatever happens in small trust happens in our trust, in big trusts, okay? Now, when we look at the 14th Amendment, we found here that we could not name the heir. The 14th Amendment names an heir. It names the heir. But it doesn't do it here, it does it over here. So here we have a separate estate that is lessened. We have a life estate that only is good for your life. It cannot pass on to an heir. And it is a trust. We're beginning to establish that it is a trust under the charitable uses. And let's try to skip on, because I think I'm going to have to have a break shortly. I wanted to see if I could find Cypress. Now, under charitable trusts is where CPRE comes up. And what CPRE means is that somebody has the ability to change the trust. In England, the king could change the trust, or the Lord Chancellor. Okay, but the Lord Chancellor only had limited capability to change the trust. He couldn't do a lot. He could only do a little bit to a charitable trust or to any trust. The king had ultimate power. In the United States, the Congress did not have CPRE power. It was not given to them. It was not one of the prerogatives given from the Crown, and it is a prerogative. It's the parens patriae prerogative, meaning parens patriae, mother of the country. Okay, the state has parens patriae power. The states. And charitable trusts fall under the CPRE power, and I'm trying to find this.
You said that the government had no CPRE power?
The United States government has no CPRE power. They exercised a power that was resembled that. I'm trying to find it in the court case, the Mormon Church court case in the latter part of last century. Bogert here says that the United States government did not have it, but they exercised something that resembled it in that particular case. He goes into governmental trust on page 162. Hopefully we'll here we are on the next page. Yes, okay. Section 432 on page 321. Judicial and prerogative Cypress powers. Sometimes I say CPRE, sometimes I say Cypress. In England, a distinction has been drawn between the Cypress power, which is vested in the Court of Chancery and is exercisable by it usually through a master, and on the other hand, the Cypress power vested in the Crown as a parens patriae, also known as the prerogative power, which is exercised by the sign manual, etc., at the suggestion of the Attorney General. The power of the court is almost always based on the existence of a charitable trust, okay, or of an absolute gift to a charitable organization. The royal power is exercised in several cases where there is a gift for charity without a trust. That's the royal power. Basically, what I'm trying to get at is when Congress applied the Cypress power to the Mormon Church, or what appeared to be the Cypress power, they took a power that they didn't have, the ability to change a trust or create a trust. It applies to this, okay? The 14th Amendment was already in existence, but they didn't have the power to create a trust. So they snuck a little bit of it, took it, the Cypress power. They didn't have the power, only the states had it. So let's see if we can sneak it through here, and nobody will look and nobody will notice, and then we'll get some clear footing here and create the Federal Reserve Act, the trust, funds, and the Social Security Act, and whatever they were going to create in the future, because they're at least 20 years in advance knowing what they're going to do. Okay, page 332, the doctrine of Cyprus is a doctrine of prerogative. This comes straight from the crown. When the king signed the Treaty of Peace, he gave the states, the people of the estates, the prerogatives of the crown. Of course, Congress did get some, but not all. Cyprus is enforced in some states. In the states where Cyprus is not enforced, the failure of a charitable trust gives rise to a resulting trust for the settler or his successors. So we're talking about the creation, the manifestation of a trust. And Congress, on page 335, it shows you that 1890 was the Mormon Church incidents where the Supreme Court seems to have sanctioned the use by Congress of something like the prerogative Cyprus. Right there, they broke our trust. They created a second trust or gave them the authority to do so. Okay, they took the authority illegally by the Cyprus power, by exerting this power that they'd never had. Now, do you get the idea of what Cyprus means? Okay, you won't get it all at first because Cyprus is like kind of scattered out there, and it's like a bee you're trying to grab a hold of. You kind of get it, but it's not really clear enough. And once you get that it's basically the power to change or create a trust, okay, then you're beginning to get it. But they did not have that power. Okay?
That would be for charitable reasons.
For charitable purposes. They had no power. The king alone has the power, which is the people, the sovereign heirs. Okay? They alone had the people. The states had the parens patriae. That's why that welfare, state welfare, is the state's business. That's their parens patriae, sovereign power. Okay, it's a charitable use, welfare, state welfare. Of course, it comes from the federal government, but they try to hide that. Moving right along. Oh my gosh, are we going to get through this? Or is okay. I feel like I'm rushing. Okay. We've hit trusts, we've hit charitable trust. We're looking at the 14th Amendment as a charitable trust. Okay, or a trust, having charitable attributes. Next, we have a few ditties on guardian and ward. 39 Amjor, 2D, section or page 159. My, what is this? A trust relationship between guardian and ward? Is a 14th Amendment citizen a ward?
What page is that? 159? Yeah.
159, section 208. Okay, it has been said that in no relation except perhaps that of parent and child or husband and wife are the elements of confidence on one side and active good faith on the other more essential than in the relation of guardian and ward. The ward is frequently a minor and often so young as to be entirely dependent on his guardian. The guardian is sometimes the ward's father or mother, and if not, sustains a quasi-parental relation. The government itself is, in a sense, the supreme guardian, whom the individual guardian represents in its solicitude for the welfare of the wards. Oh, what wards?
Yeah.
Oh, you mean there must be specific wards? I doubt it. Guardianship, therefore, has been said to be a trust of the highest and most sacred character.
Oh, yeah.
Now, believe it or not, they are a guardian up here. It is a trust of the most sacred and highest character. They are also a guardian down here, guardian-ward relationship in the 14th Amendment area. Okay? Different effect and different rules and different principles. But they are still a guardian of our covenants and trusts and everything up here in the preamble of the highest character. This is parens patriae, okay? As you notice on the side, it defines actually parens patriae. Now, down at the bottom, you notice that the confidential relationship immediately arises between a person-appointed guardian and his ward for the benefit of the ward upon the guardian's taking his oath, executing the required bond, entering on the discharge of his duties and receiving as guardian property, money, or effects of his ward. These people have taken oaths, they have bonds, they have entered upon the duties, they are guardians, it is a trust, and when we get right down to it, these oaths, the oath is where God lies, and the bond is what needs to be attacked. Okay, next page, page 26. What they're discussing here are wards being infants or other incompetents. The heirs of the preamble estate are neither incompetents nor are they infants. They were sui juris and in their majority, meaning that they were of age 21 years old, they were citizens and therefore could vote. 14th Amendment citizen, on the other hand, is either or an infant or incompetent. That is what the 14th Amendment was created for. Infants or incompetents. Okay, continue on. Here we have things on infants and incompetence, protection and custody. Now we get into the parens patriae, which is attached to Cypress. The state, through its proper organs, exercises its power for the protection of infants, since, page 20, since it, as parens patriae, is the guardian of the children within its jurisdiction. The federal government, however, does not stand in the position of parens patriae with reference to the persons and property of infants, except in the territories and the District of Columbia. The United States government does not have parens patriae power. The states have parens patriae. Oh, except in the District of Columbia and the territories. At this point now, yes, it is the states as defined under the Buck Act. Okay. But the states as defined under the Buck Act, which is found in Title IV. Okay. Once they statutorily define something, they change it. For example, employment has been statutorily defined under the Social Security Act. It is no longer the employment that we know it as here. Okay, it is owned, possessed, or ceded to. Once something is statutorily defined, the United States now owns it, or it has been ceded to it, is now falls within the corporate mortmain capacity. Boy, they've really shredded this country apart, haven't they?
Ye old shredder.
This poor woman here looks like she's about ready to cry or like, oh no, I didn't know all this. It gets overwhelming. You know, what they've done looks overwhelming, and we really must try to we know what they've done. Now we know really what they've done. You know, we're down to the nitty-gritty here. Again, on page 21, they bring into the discussion parens patriae. The state as parens patriae is authorized to legislate for the protection of care for the care of children under its jurisdiction. Now, when we're talking about infants, okay, we're also bringing in the incompetent people, okay, because they all fall in the same hat. Okay, infants and incompetents fall in the same hat. So this applies to them. Now, when you're an infant, let's see, the jurisdiction of equity over persons of property originated in the it originated in the prerogative of the Crown of England. Okay, arising from its general duty as parens patriae to protect persons who have no other rightful protector. Oh God, I don't know if I have another rightful protector. This goes into heavily what parens patriae is. Now, on the next page, on page 66 in section 65, you will see something that says liability for necessaries. This is a principle applied to the Social Security Act and your income tax and et cetera, et cetera. It is well established that an infant is liable for the value of necessaries furnished to him. If you're an infant or an incompetent, you're liable for the necessaries furnished to you. An infant's liability for necessaries is based not upon his actual contract to pay for them, but upon a contract implied by law. Have all you people been asking for the contract? You know, where's the contract that I signed that said I have to do this? It's right here. Because it is presumed that you were being supplied the necessaries of life to take care of an infant or an incompetent. Or in other words, a quasi-contract. Thus, an infant is liable for the value of necessaries if they are furnished to him under such circumstances that a promise to pay for them can be inferred. And he is likewise liable for necessaries furnished to supply his urgent need, even though he is too young to understand the contract for such necessaries. Next page, 67. The rule that an infant is liable for necessaries furnished to him was incorporated into Section 2 of the Uniform Sales Act, which provided that where necessaries are sold and delivered to an infant, he must pay a reasonable price for, although the comparable provision in the Uniform Commercial Code, voila, the UCC comes up, simply provide in part that unless displaced by the particular provisions of such code, the principles of law and equity and the law relating to capacity contract, etc., 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 he's bound by his contract. Right here is where you get the contract that the Social Security is upholding against you because you're an incompetent or an infant obtaining its necessaries. You will also find that in the next one under incompetent persons. An incompetent may become liable by way of contract implied in law for necessaries provided to his dependents or to himself. Next page, what are necessaries? The determination of what article is furnished an insane person, oh my gracious, our necessaries depends not merely on their nature but also on whether they are proper and suitable according to the circumstances and his condition of life. The term is not restricted to articles that are basically essential to existence, but includes all articles and services proper for the normal maintenance of the incompetent. The wants or needs of an insane or other incompetent person, which are personal to body and mind, are necessaries. Here you have all the necessaries in life being provided to you by the Social Security Department in a social welfare state. Do you see it? Do you see the necessaries being that everything now can be construed as a necessary being provided to you as an incompetent person? Under this estate, are the building blocks building up from this coming down? Yeah. We also mention how a trust is terminated. There's no one inflexible mode for termination of the trust. We are all terminating this trust. Mm-hmm. When you apply for that Social Security number, you terminate this trust. You repudiate it. When you send in that 1040 every year, you repudiate the Constitution itself. That driver's license, everything the laws have been set up to do, force you to repudiate the trust. Now on page 388, we're going to go into spendthrift trust and similar protective trust. Now, the Federal Reserve Act, I tried to find the tape, somebody way back when the Federal Reserve Act was passed, some prominent person said that this creates the largest trust ever known on the face of this world, or earth, or something to that effect, and I couldn't find the tape as to who said it.
Yeah.
Oh, it was you. It was in your tape then.
Probably.
Because it was.
McFadden?
Yeah.
Okay, that creates the trust. Okay, the 14th Amendment per se did not. It created a life estate which diminished this estate. Now, in my perception, the Federal Reserve Act, in conjunction with the Social Security Act, diminished the estate one more time. And I perceive it a possibility to be a lesser estate and one that is not a freehold estate. Even the 14th Amendment is a freehold estate, but it is a life estate. Okay? So now the estates are becoming diminished and more restriction is being placed on us, And we're going back into feudal times and servitudes and serfdoms and slaveries as the estate is being diminished, because that is the only way it can go. It is going in that direction. It already has. And we're going to get into the spendthrift trust here, because the 14th Amendment, the Federal Reserve Act under the 14th Amendment, created a spendthrift trust for incompetents and infants who were wards. Okay? Income of the trust by the beneficiary. Page 388, section 147. The scope of this division is not merely technical spendthrift trusts and other trusts aimed at protection of beneficiaries against their alienees and creditors, but it includes all trusts aimed at protection of beneficiaries in present or future support and maintenance, including education, even though their protection may be merely against the direct control of the res. Okay, direct control of this res? It's prohibiting us from being in direct control of this. You can basically say that that's exactly what that just said. Or income of the trust by the beneficiary, and not against alienation by him or against his debts. As a matter of fact, two chief situations exist where a support or similar trust is protected merely against direct control by the beneficiary of his interest in the trust estate. Okay, down further you will see, about the third line up, it's basically to protect himself against his own improvidence or incapacity of management, a trust of which character cannot, according to the universal rule, protect the settler against his own acts of alienations or debts. Now, this 14th Amendment so-called trust under the Federal Reserve Act is supposedly protecting our improvidences in this. You know, like if we had this, we couldn't handle it correctly. They may be right. There's a lot of ignorant people in this world. God forbid. I mean, our country is already in the hands of ignorance. I should know. I have been there. I have been ignorant. We all have. Let's try to find more understanding and bring ourselves out of darkness. Okay, definitions and distinctions. In a broad sense, a spendthrift support or other similar protective trust is one created to provide a fund for the maintenance of the beneficiary, voila, the Federal Reserve Act, and at the same time to secure it against his improvidence or incapacity. So therefore you see that the Federal Reserve Act was totally lawful for certain persons. Okay? In other words, it bars such interest from seizure in satisfaction of debts. The name Spendthrift Trust is poorly descriptive, since no spendthriftiness or profligacy. Thank you, profligacy. You say it. I'm a little tongue-tied. Sometimes I flip words around. A little, of a beneficiary is requisite or open to inquiry and determination of the existence of such trust. While spendthrift trusts are usually regarded as inclusive of all trusts, which bar creditors from reaching a beneficiary's interest, that's interesting. I think the banks really get to us. They are, in strict legal nomenclature, to be distinguished from other trusts seeking to protect a trust estate against the grantees. Now, let's see. Down in the next section, there will come up the word inherent. Okay, if they're assuming there is no inherent objection to spendthrift discretionary support and other protective trusts, I don't recall anybody having any inherent objection to the Federal Reserve Act. Nobody complained about it at the time. Certain prerequisites must appear before a valid trust of this kind can be said to be created. While it is not essential that the beneficiary be in fact a spendthrift, or that the settlor state his reasons for and motives, it is essential to the existence of a trust of this character that there are some restraints, okay, on the immunity or of the interest or benefit of the cestui. Now, we're placing controls on the beneficiary here. In section 159 on page 398, you will see that a beneficiary of a spendthrift trust may, prior to accepting the trust, effectively disclaim or renounce the trust. They didn't even tell us that was available, did they? Now, on page 413, or should I go backwards one more?
On which page?
Let's go to 413, section just above section 177. The last paragraph says, a beneficiary of a spendthrift trust has been required to repay an overpayment to him out of the trust. Okay, we start seeing the 1040 here. You're a spendthrift beneficiary of a spendthrift trust, and every year you've gotten too much money from the trust res, so you have to return some of it on that 1040. Page 415, section 179. The beneficiaries of a spendthrift or other support trust are entitled to the benefits conferred in accordance with the terms of the trust, expressed or implied. Of course. Generally speaking, the operation and effect of such trust in respect to benefits are governed by rules and principles applying to provisions for support, whether in wills, like the 14th Amendment Codicil, deeds, contracts, declarations of trust, or other instruments. Support trusts quite commonly are based on support contracts. There's your Social Security Act, a support contract. And being thus purchased for a consideration. Here's your Uniform Commercial Code. Subject to, what did you buy? Where's the contract? Or is all of this falling in? Okay? I hope so. Section 180, where it's marked down, where it starts, such a trust casts upon the trustee the duty to exercise sound judicious judgment, to determine what is necessary for the support of a beneficiary, and to turn over to him trust income or property or funds in such amount in accordance with the terms of the trust. Page 417, section 182. The trustee, under a spendthrift or other support trust, is often vested with discretion to determine the occasion or amount of support payments or other benefits or other occurrence of or compliance with conditions entitling the beneficiary to a payment or to the corpus of the estate. Now, this is saying that they have the right to determine what we can have. Now, if you have never been in an audit with the Internal Revenue Service, you will not relate to this. If you have been in an audit, you will actually get in your gut that they are making the determination as to what you can have. Well, we disallow this. Well, we disallow that. And you're sitting there going, I did this in full faith. I did this in honesty. And they're throwing it out the window. And that person is determining what I can have.
Or you only treat this as a person, Mike.
On the next page, you will find a request for an OMB review. This is SF 83, Standard Form 83. This is regarding the Social Security number. This comes from the Office of Management and Budget. In number 4 there, you will see it does refer to the Social Security. It says application for a Social Security number card, original, replacement, or correction on Form SS5. Please forgive that these things have dark backgrounds because they were marked in a pencil or marking device that was copyable. We weren't quite sure. When you look at this carefully, you'll notice in number 9, it says CFR section affected. There are none. And if you go to the next page, it'll give the description, Social Security benefits, application number, original replacement, etc. And a pertinent part of the form is number 24. Respondent's obligation to comply. You will notice that number 1, voluntary, is not marked, neither is number 3, mandatory, but number 2 says required to obtain or retain a benefit. That is what a Social Security number and card is for. That comes directly from the OMB, which is the office below the President of the United States. Now, the Federal Reserve Act created the trust and the fund of the trust. The Social Security Act created your ability to receive benefits, and the number here shows, or this OMB request shows, that it is only to obtain or retain a benefit from this spendthrift trust fund. Page 419, section 184. In the absence of anything in the trust declaration indicating the amount of support benefit, which it wasn't in the Federal Reserve Act, to which the beneficiary is entitled under a spendthrift or other support trust, the amount thereof is to be determined by the trustee in the light of the station of life, your status, and mode of living of the trustor and the beneficiary, the relationship between the two of them, or between them, and the needs of the beneficiary. Here's your 1040 being defined. It's starting to be defined, I should say. Okay, the Internal Revenue Service now comes in. The trustees make a determination. What is your status? Please send us your Social Security number so that we might know who you are. What is your status in life? What is your status in this country? What is your status in relationship to the preamble? What is your estate? 422, page, section 187. While compliance with or the occurrence of conditions precedent and conditions subsequent, it is a requisite to the right to receive. Remember that from the charities. Or retain the benefits of a spendthrift, support, or similar trust containing such conditions. Compliance with or occurrence of conditions precedents and conditions subsequent. I could go into that, but conditions precedent and subsequent is another book, another page. Okay, now 423, place of support. How many of you have heard that the income tax applies to you no matter where you reside?
Yeah.
Okay. Section 188. A beneficiary of a spendthrift or other support trust generally is entitled to support, of course, or other benefit under the trust irrespective of where he resides. This ties the two in. You're subject no matter where you reside. You can receive the benefits anywhere you reside. This is... everything starts tying in together now. Melding, becoming one, becoming clear. Page 427, application of statute of frauds and wills. A trust by operation of law, whether it is resulting or constructive, is not within the statute of frauds and is not required by the statute to be created or proved in writing. Neither do the provisions of the statute of wills apply to the creation of such trust. Such trust may be established by parole evidence. Okay? Further down in there, a trust of this kind arises from the fact of consideration, or the fact of fraud, or wrongfulness giving rise to unjust enrichment, and not from a written agreement, instrument, or will. And rest on estoppel. The purpose of statutes of fraud is to prevent, not to permit, the consummation of fraud or unjust enrichment. Now, we skipped over a few things here, but we're getting into the idea of a constructive trust is created because there's fraud located somewhere there. I call the 14. I call this, when I'm talking to the bureaucrats at this point in my life now, I call it a constructive spendthrift trust by implication of law. Okay. I think it's a good terminology. I say it's a spendthrift trust. There is fraud involved somewhere here, so it's constructive, and it is basically, and again, by implication of law, because you can't find it written down anywhere. It is definitely implied. There is definitely an implication that this thing exists, even though they failed to inform us and to write it down so that we could see it and find it. You could even call it a spendthrift trust by implication of law, or just spendthrift trust. Definitely have spendthrift trust there. Resulting trust, 429. The doctrine of resulting trust is a familiar one in equity jurisprudence. Broadly speaking, a resulting trust arises from the nature or circumstances of consideration involved in a transaction whereby one person thereby becomes invested with a legal title but is obligated in equity to hold his legal title for the benefit of another. Here is the constructive trust, 446, section 221. A constructive trust, otherwise known as a trust ex maleficio, a trust delecto, ex delecto, a trust de son tort, an involuntary trust. Involuntary. That's why I call it constructive spendthrift trust. Okay, it's involuntary. It's also one created under tort. Their tort. Or an implied trust, is a trust by operation of law which arises contrary to the intention and invitem against one who, by fraud, actual or constructive, by duress or abuse, those are familiar words, of confidence, absolutely, by commission of wrong, or by any form of unconscionable conduct, artifice, concealment, or questionable means, or who in any way against equity and good conscience either has obtained or holds the legal right to property which he ought not in equity and good conscience hold and enjoy. Somebody's got my property and I want it. Perpetuities. Perpetuities, okay? Now, if you look at this and you go, okay, it's perpetual, there is a rule against perpetuities, okay, but it does not apply to charitable trusts. It applies to private trusts. That's what makes this a charitable trust. That's what makes the 14th Amendment a charitable trust. This makes them kosher in the eyes of the perpetuity rule. Okay, now they can last forever and ever and ever.
Amen.
That's why I've been bringing all this stuff in charities in here. Because you can't just say, well, it's a trust, and say, well, what about the rule against perpetuities? Oh, you wouldn't know what to say. Well,
this is all statutory law.
This falls under, no, this is common law. Well, no, what I'm talking about is common law, okay, and that they've diversified common law to statutory form.
Perpetuities, though, is basically
Oh, perpetuities go back a long time, yes, long time, to the statute of uses, because that's what they wanted to break in England on the corporate structure of under Mortmain. They were trying to break the perpetual hold of Mortmain through the Catholic Church. Corporations are not subject to perpetuities, okay? And the Catholic Church had England in its grasp, its death grip. So way back when is when they came up on the perpetuities in regards to trusts. so that a private trust could not be perpetual. Okay, a charitable trust could be, but there are a lot of restrictions on charity. That's where the rule of Shelley's case goes way back. Okay, I told you once that restraint on alienation was found under perpetuity, so I've thrown some of it in there. Okay. The general rule is that one of the incidents of ownership of property is the right to convey it. Okay, and the law will not permit the rights of ownership to be fettered by the imposition of restraints by grantors or testators who seek to convey or dispose of their property and at the same time maintain control over its alienation or use. The United States government has restrained my alienation on this property, and it is a restraint on alienation under this right here. They're trying to control my property, my estate. This cannot be allowed. Thus, whether imposed by deed or will, deed or 14th Amendment will, restraint on alienation is ordinarily a void, except under the 14th Amendment it's a spendthrift trust, and remember it doesn't apply to spendthrift trust, so therefore restraint on alienation is perfectly valid under the 14th Amendment, and that makes the Social Security number okay. The Federal Reserve Act is okay. It's all legal and lawful. On page 110, statutory and constitutional provisions. Ever since the passage of these statutes, and we're talking about quiem toris and other English statutes, okay, the right of alienation has been treated as an incident of an estate in fee simple, and one which cannot be avoided except by an agreement which is not unlawful, impossible, or repugnant to the grant, or inconsistent with enjoyment of the estate granted. Okay, that's how they created the 14th Amendment. It truly is not repugnant to this. Okay? Like I said, you can have a large estate and make it into smaller estates. So, again, we say that the 14th Amendment doesn't, the restraint on alienation does not apply to there, but it does apply to this. So we got to go for that allodial title, that fee simple absolute. On page 119, restraints as to persons. According to the prevailing rule, where a deed or device in fee simple contains a provision or condition limiting the class of persons to whom the property may be aliened, or excluding a certain person or class of persons from owning such property, such an attempt limitation on the right of the grantee or devisee to alien the land is void. We keep coming up with this voidable thing under the restraint on alienation. Did I mention that I sent the Social Security Department a affidavit in support of restraint on alienation? I defined their restraint on alienation as a number that they had given me under mistake of law through non-disclosure. It's a nice two-page little article. It's an affidavit, basically. Unlike the revocation of powers of attorneys that some people are putting in, this hits straight toward an estate because I brought that up. The fee simple absolute. I put them on notice again and again. It's about the fourth time I put them on notice of something, but this time it's on their restraint of alienation.
Any response?
It was just a couple weeks ago that I did this.
No response yet. Okay.
No, I gave them 10 days, but they didn't respond in 10 days. So.
That's all I give you.
Hey, 5 minutes is too long. Yes, that's right. That's how long they give you. And we're going to continue on here further. Let's see, where are we here now? On page... You'll find something that says up the top on the left-hand corner, section 275, general provisions. This comes from the California Probate Code. Section 275, beneficiary filing disclaimer. A beneficiary may disclaim any interest in whole or in part by filing a disclaimer as provided in this part. What are we disclaiming?
Federal law.
This is under probate code. We are disclaiming being a beneficiary under the constructive spendthrift trust by implication of law. We are revoking elections. Disclaiming. We are not going to take under the will. Okay? It's a disclaimer. This is the probate code. This gives you the right to disclaim taking under the will, or, revoking those elections, or saying, hey, something about the elections that was forced on you. On the next page is section 280. Filing of disclaimer. A disclaimer may be filed with any of the following. Number 1, the Superior Court. A disclaimer shall be filed with any of the following. Number 1, the Superior Court in the county, etc. Number 2, the trustee, personal representative, or other fiduciary or person responsible for distributing the interest to the beneficiary. Now, this is the government, the trustee, the representative, the corporate capacity. Okay, you can file your disclaimer of testamentary interests, as you may, with the government, state, federal, etc. Number 3, any other person having custody or possession of or legal title to the interest. Could that be the banks? Number 4, the creator of the interest. I think they're dead. 4B, the disclaimer in this part may be filed with the county, recorded in the like manner and with a like effect as a grant of real property, and all statutory provisions relating to the recordation or non-recordation of conveyances of real property and to the effect thereof applying to the disclaimer with like effect. Now, I tried to file my disclaimer with the county recorder pursuant to this section, and they have refused me not once, not twice, but 3 times. Now, I figure if they refuse to file it, it must be valid.
Not only valid, but probably deadly.
It's probably deadly. But we shall pursue and continue. Okay, probate code. Probate court is an Article 3 court. Believe it or don't. And the probate codes have wonderful remedies regarding the breaches of trusts and the accountability of the trustees and making account to you. Utilizing it, I don't know. I haven't applied it in that direction as yet. But it looks like a possibility and could open up several doors. I would love to open some doors in probate court. This is a trust. That's where it belongs. It's the 14th Amendment. It's a trust. That's where it belongs. And it doesn't matter if it's a court of equity or not, because once a trust is brought in, the court has to look at trust first and other laws later. The trust comes first. Now, page 188, section 278. Here we discuss the disclaimer and what you're disclaiming. You're disclaiming your election to take under the will, the 14th Amendment codicil. You want to disclaim it. You want to tell them that they took you. They committed non-disclosures. They didn't tell you of your rights as an heir to this estate. They told you you were someone else and that it was an inferior estate. This is the guidelines on how to make one. Page 203 in section 295. Effective federal law, transfers of or disclaimers. Notwithstanding any other provision of this part, if as a result a disclaimer or transfer, the disclaimed or transferred interest is treated pursuant to the provisions of Title 26 of the United States Code as now or hereafter amended or any successor statute thereto, and the regulation promulgated thereunder as never having been transferred to the beneficiary, then the disclaimer or transfer is effective as a disclaimer under this part. Here we have Title 26 in the Probate Code. My.
Oh, wonders never cease.
Now, as an estate, and as A conveying Blackacre to B and his heirs, in law, under common law, under English law, the heirs had to be lawful heirs. And when there were heirs, there had to have been a marriage. A marriage between the testator or whoever was doing a wife, because if there weren't, the posterity would be bastards, unable to inherit. In metaphysical thinking, there is a wife who created the posterity of this country, a mother. Your mother, my mother, my mother country. The founding fathers were married to America, and America gave birth to the heirs of liberty. In this metaphysical line of thinking, in order to separate and segregate the estate, we can utilize dower, assigned dower. It literally separates the estate. We give the widow 1/3 of the estate. We can give her this. The rest all comes with it. Now this is metaphysical thinking. How to do it? We've been trying to get in an assignment of dower also to separate the estate. And it sounds interesting, unusual, but it was a valid thing. And they were married to America. And the heirs are not bastards. We are lawful heirs. So we must have a mother, and she deserves to be assigned her dower. And it does separate the estate and get it out of other people's hands. It could be something fun to play with. In dower, you can quarantine the estate. Her estate. Just put it on sheer quarantine. Okay? These are some very beautiful things to look at, because she is your mother country. She is my mother country. She is your mother country, no matter what color, sex, religion, race, or anything that you are. She's my mother, my spiritual mother. Read the dower sections that I put in here. Try to relate back to what I said, or am saying here, about, here on page 222, on the second paragraph, the assignment of dower is essentially a different thing from dower itself. Dower is an estate, while the assignment of dower relates to the remedy for segregating the estate. Now, it's very difficult to segregate our estate from this corporate function that is going on, this mortmain situation we have. You know, God forbid, we don't want a war, we don't want bloodshed, but dower could be a possible legal way of segregating the estate. I don't foresee much hope in it, but it's a beautiful line of thought, because now we're going to get into the law of real property, freehold estates. freehold estates, characteristics. Okay, now the 14th Amendment over here, Section 12, and that's page 58. A tenant for life of a possessory estate has a right to the undisturbed possession of the land and to the income and profits. Now we're getting into life estates. 14th Amendment is a life estate. Okay, but on the next page, on page 59, it says his use and enjoyment of the premises is limited by the law of waste. That is, he is under duty to refrain from any act which will diminish the value of the reversion or the remainder, if such an act is also under all of the circumstances and unreasonable use of the premises. This particular area defines the 14th Amendment estate. Okay, not the trust. The trust falls under the estate. Everything goes in a nice lineal fashion. Okay, we start with the estate up here, and everything falls beneath it. There's things that fall beneath this estate, and under the 14th Amendment estate, other things fall. So these estates have been established hundreds, who knows, thousands of years back. It's like a scientific formula. They have it down pat. They know exactly, whoever they are, know exactly what something is, how it behaves, how it acts, and you don't. I swear they must have diminished the value again. These estates normally involve a duty on the part of the estate holder to make a periodic payment for the use of the land. How about a yearly 1040? They compromise the core of the landlord-tenant relationship. Ever feel like you were just a tenant on your own property? I swear they are diminishing the estates. We're going back into feudal times, into slavery. Let's go to volume 49. Landlord and tenant is more. This goes into whether you... Now, this is where employment comes in as a tenant, and I want you to read this at your leisure. See if I can... Okay, while a deduction from wages of a specific sum for the use of the premises or the absence of such an arrangement would be a material circumstance, it would not be in all cases conclusive either way. Here we're talking about a deduction from wages for use of premises. Now, we're not going to go into that right now, but this is, now we have a W-4 form coming in. What premises are we using? So obviously the estates are being diminished. And on page 325, you will find the W-4 further defined under assignment. This is from Amjur 2D, and assignment for the benefit of creditors. A general assignment for the benefit of creditors is ordinarily a conveyance by a debtor without consideration from the grantee of substantially all his property to a party in trust to collect the amount owing to him. Down further it says something about return the surplus, if any, to the debtor. The common law, next paragraph, also embraced, in addition to the general assignments, a non-liquidating device known as a partial assignment, by which a debtor could transfer a part of his property in payment of creditors. Now, does this sound like a W-4? And under the principle that a debtor may, while he retains dominion over his property, dispose of it as he chooses, an assignment of part of his property to part of his creditors was valid unless it could be attacked as a fraudulent conveyance. Here we have, remember, an exempt W-4? Was valid unless it could be attacked for fraudulent conveyance. Page 232, I try to show that the assignment, the W-4, is an assignment as security. Wage assignments, of course, wage assignments are something totally different in the minds of human beings, but I see the W-4 as an assignment for the benefit of creditors. Okay.
Exactly.
And you do, it's partial. Origin and development of death taxes. Now, since everything has to work together, okay, someone has to die in order for a gift tax or an inheritance tax to apply. In our case, the heir dies. The 14th Amendment citizen is responsible for the estate or gift tax of the trust. And I want you to go through that when you can. Inheritance taxes. These are very important things. The legislature has the power to classify property for estate tax purposes. Now, when you look at our state and the 14th Amendment state, the legislature has the power to classify the estates for tax purposes. Since the 14th Amendment is an estate, they have the power to classify that tax, and it would have to be either an estate tax or something else. Now, when I started researching this, on the label, I wanted to find out if the 1040 was a will, a codicil, or what. And what I ended up with was that the 1040 is a gift tax. Indeed. That it was a deed, not a will or a codicil, because it took the description more of a deed than it did a will. It is an absolute gift to a charitable use, a corporation in Maine for a charitable use. Now, I thought perhaps it could be an estate tax, but gift tax supports it better, in my eyes. If you find that it's different, let me know. Let me know.
Also, the 6209 manual lists the W-4 as a gift form.
That's right. The 6405, what manual? IRM?
6209, I think.
Okay, the Internal Revenue Manual 6209 lists the W-4 as a gift tax. On page 860, Bills and Notes, section 54. A note, an evidence of debt. Okay, we are discussing. As they choose an action, a promissory note of a third person or other evidence of debt together with any security may be the subject of a gift inter vivas. Right here it says that you can give a debt as a gift. Well, I want you to know that those Federal Reserve notes are evidences of debt. And you are giving your evidences of debt as gifts. Or you're transferring them or conveying them to other people. Okay, so there you laughed, huh? Those Federal Reserve notes are evidences of debts.
Causa mortis.
Causa mortis. Please read causa mortis and gifts, because causa mortis is very important. The idea of someone has to die, okay, for a tax on a gift. Okay, and when you think that someone has to die, remember the heir here has died, the 14th Amendment citizen is paying the tax because the estate or some sort of estate has transferred. It's all metaphysical, but has transferred to a 14th Amendment citizen. The 14th Amendment citizen has to pay a gift tax because the heir is dead. The 14th Amendment citizen genocided him, along with the government. It's conspiracy. None dare call it conspiracy. Now, I want to wrap this up very quickly, and we're going to go to Title 26. Well, you'll recognize it by the top says 6100. This is Title 26. But the section is 2501, imposition of tax. This is the gift tax section. In general, a tax computed as provided in Section 2502 is hereby imposed for each calendar year on the transfer of property by gift during such calendar year by an individual resident or non-resident. Transfers of intangible property. Except as provided in paragraph 3, paragraph 1 shall not apply to the transfer of intangible property by a non-resident, not a United States citizen, or not a citizen of the United States. Now, do you notice that it does not say non-resident alien?
Yeah.
It says non-resident, not a citizen of the United States. Right. Okay, and intangible property doesn't apply. One a bit. Exception, paragraph 2 shall not apply in the case of a donor. Well, you are a donor, who at any time after March 8th, 1965, and within a 10-year period ending in with the date of transfer, lost United States citizenship. Now, this is about expatriation. Okay, so this one doesn't count. We just, let's involve ourselves with number 1 and 2. And go to the next page, and up the top, little b, 2501b. Certain residents of possessions considered citizens of the United States. And if you will see in number C, or letter C, certain residents of possessions considered non-residents, not citizens of the United States. I want you to know there is absolutely very little difference between the two of those definitions. You'll be almost reading double when you look at them. You go, what? Wait a minute, the other one said exactly the same thing. In there, it gives the requisite for either being a citizen or not a citizen. Okay, but let's read C. A donor who is a citizen of the United States and a resident of a possession thereof shall, for purposes of the tax imposed by this chapter, be considered a non-resident, not a citizen of the United States. Didn't he just say it was a citizen of the United States? Within the meaning of that term, wherever used in this title. I only find that particular wording in this area. You could literally confuse it with non-resident alien, but these words are nowhere else to be found in Title 26. But only if such donor acquired his United States citizenship solely by reason of, number 1, his being a citizen of such possession of the United States, or 2, his birth or residence within such possession of the United States. Well, this kind of makes it, this is very convoluted. They bring up the word possession of the United States and your birth in that possession. And from what I know of the Buck Act, this is all a possession of the United States, so I'm a non-resident, not a United States citizen, according to this definition, pursuant to the Buck Act. And the wordings of both of these are so convoluted as to make you wonder what in the heck is going on.
Yeah, where did the bear go in the buckwheat?
So if you're using non-resident alien, then you're declaring yourself to be a Frenchman.
You could be a Frenchman, because I do not find this particular wording anywhere else, and it does say anywhere else where in this title, not sections, but in this title, I find it nowhere else except under gifts and estates. So, if under a state law I'm a non-resident, not a United States citizen, does that make me a non-resident alien under some other section? I don't think so. I don't think I'm a non-resident alien. I may be a non-resident, not a United States citizen, but I don't think I'm a non-resident alien. I'm an heir. I'm still going for the heir. Now, turn the page again in section 2511, the little b portion. Intangible property. Remember, the non-resident, not a United States citizen tax did not apply to intangible property. For the purpose of this chapter, in the case of a non-resident, not a citizen of the United States who is exempted from the application of Section 2501A2, shares of stock issued by a domestic corporation and debts of obligation.
Frog notes.
A United States person, or B, the United States, a state or other political subdivision thereof, or the District of Columbia, which are owned and held by such non-resident shall be deemed to be property situated within the United States. Your Federal Reserve notes are property situated within the United States. Pursuant to this definition, that's why nobody has been able to say, hey, I am not employed or getting income from within the United States. You're not. The Federal Reserve note is. This just makes it thus.
So Howard Freeman's argument there figures directly to those notes.
Yeah. And where we get this from is on the next page, Title 31. Let's see if I have that marked. No, let's go to the next page over there. There's the United States can accept gifts on Section 3113. Isn't that generous of them? To provide the people of the United States with an opportunity to make gifts to the United States government to be used to reduce the public debt.
Where are you?
Section 3113, page 249. Okay, it's Title 31. To provide the people of the United States with an opportunity to make gifts to the United States government to be used to reduce the public debt. Isn't that what your 1040 is used for?
Sure.
Supposedly. Will that public debt ever be reduced? Never. This is... Now you can turn the page to Section 3121 of Title 31. Little b1 says, under conditions prescribed by the Secretary, an obligation issued under this chapter and redeemable on demand of the owner or holder may be used to pay the United States government for taxes imposed by it. The obligation imposes the tax. Imposed by it. The obligation imposed the tax. And turn the page one more time to page 267. This comes from Title 31, and we're going to go to Note 58, Treasury Notes. United States notes issued under acts, etc., 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 is still valid. Intended to circulate as money, and actually having constituted with the national banknotes the ordinary circulating medium of the country, were moreover obligations of the national government. The money is the obligation. The Federal Reserve note is the obligation, the debt obligation. It is the note. It imposes the tax under the gift tax as far as I can see, or estate tax. If I am wrong, please prove it to me. And on the next page, 257, you shall find exemption from taxation. And this is the last page, and we can then talk about the whole situation. The tax status of interest on obligations and dividends, earnings, or other income from evidences of ownership issued by the government or an agency, and the tax treatment of gain and loss from the disposition of those obligations and evidences of ownership is decided under the Internal Revenue Code of 1954. Now, do you agree with me that the possibility that this is a gift tax or an inheritance tax exists?
Yes.
Do you agree with me that there is an estate of two types, one for a lesser estate, for incompetent people, infants?
Yes.
Are you heirs of freedom also?
Absolutely. Absolutely.
Well, I want you to tell everybody you meet, or introduce yourself, or proclaim your airness, your airsistrariousness, because when I found this, I thought it was the most beautiful thing I've ever found in my entire life, and it just all fell right down into place. And there is much more to see, but I tried to give you just the bare essentials and try to keep it as clean and clear, so not truly confuse you. And if you go out and research it, please be aware that they have commingled the two estates. This is not correct, nor is it right, nor is it legal, nor is it valid. When you have a trust, if you own corn and the trustees make whiskey, you still own the whiskey and the dregs of the corn. And you have to identify the property. It's called tracing the trust, or what is it called? You're actually tracing the property, identifying the trust property as it goes down. If you can identify the property, you own it. For example, the right to travel is part of this estate. Oops. And I ran across something very interesting on pedestrians. A pedestrian has a right to travel on any means of conveyance he chooses. He can use a highway anytime, day or night. Is a pedestrian perhaps whiskey from our corn? Because that's where the right to travel has gone, this constitutional right. It started looking very interesting to me in the DMV code when it didn't define a means of conveyance. And as a matter of fact, I can't really find the definition of a pedestrian too clearly defined either, except that he does have the right to travel and that he can use a highway anytime, day or night. And there are certain rules that apply to him, the rules of the road.
Yeah.
And it starts beginning, there are some court cases that we're trying to find and bring up regarding how they define pedestrian, and could it possibly be that this is trust property convoluted? Because when they convolute and commingle the trust property, it's illegal. It's an illegal action on the trustee's part. What you owned as corn is now whiskey, and you can't identify your corn in liquid form.
No, you can have it.
But the whiskey still belongs to you. All you have to do is identify it and trace it. Trace how they brought it down. Ladies and gentlemen, do you have any questions?
Point. If you can't get the dower or the assignment of dower registered with the county clerk or whatever, might I suggest maybe putting it in a paper where it becomes public knowledge, and thereby if everybody knows about it, this estate is separate.
Well, I could do that. However, I don't have the funds to do that at this point. It's rather expensive. There are other means of doing it. We could publish it on a courthouse wall, and then by affidavit prove that it had been published in the courthouse wall.
Yeah, that would be the way out.
Now, there are ways to do it. There are many ways to attack. I also wanted to touch upon the fact of their oaths and their bonds. Okay, at some point in here, I mentioned that they took oaths, they had bonds, they had duties. Okay, now in employees and officers, employees, okay, of AmJur, the oath, the bond. There is a contract between the sureties, their insurance, whoever insures them, okay, they have sureties. The officer is a principal, and you are the obligee, okay. There is a contract between the three of them. They owe you a duty to uphold the law by way of their bond. They have put up a bond saying that they are going to uphold the Constitution of the United States. This is their oath. When they breach this oath, the oath to support this, they default on their bond. When they default on their bond, they break a contract, and now we have a way to possibly go toward the commercial lien process because they have left it open themselves. And when it comes to their oath, This is the only place that God resides in their universe. This is an oath to God that they will get the punishment of God. And as free agents of, and representatives of God on this world, I will go after them. I am His free agent and His representative, and He shall find us a way, because this belongs to Him and He gave it to me. May God bless you.
And what did I say? It's all biblical. You got to know what God is. It's not a metaphysical concept. It's not fake. It's not something you don't believe. They made it metaphysical, so you don't believe in God. They made God like a scary character. No. God set the rules, G. Press 1. You break them, these are the consequences. So everybody pretty much you can stand in judgment here. It's a lot of things that can happen. You may think it's natural, but it's supernatural. So, but the truth is, it's a lot more to this story than we all thought. And what God is, what government is, what law is, what a sovereign is, what a citizen is versus heir to something other than some 14th Amendment with no inherited right. So it's a beautiful time to be alive. You support this broadcast, go to Gil's Gang on my Cash App, contribute to the page. Shout out to the people. Let me read these out before I get up out of here. I finally finished this so I can move on. And tomorrow in class will be much more. But let me read this support team for the day. Shout out to you people in the chat room for understanding or trying to sitting there and bearing with us over here. Todd, shout out to you. Jason Harris, Jeanette Priester, shout out to you, Queen. Teresa, shout out to you, Queen. TC, Brian, shout out to you. Yash Chosen, shout out to you. God bless y'all. I see y'all tomorrow. We're going to have probably Q&A if you like, but I'm going to continue on with the language of law, of course. And if you, Tazariak over there at Sarnetta should know this. I told y'all about the metaphysical. I told y'all it all happened here, and it's not dealing with the type of law that like the Hebrew Israelites is coming on to say. Remember, they're like the Pharisees. Remember, Jesus said, "Do what they say, don't do what they do." They'll never follow what they do, and what they're supposed to be doing is following the law, not debating Bible scholars with atheists. Press 1. You're supposed to be following the law. What law? Laws of this world, the laws of this nation. From Levitical to ecclesiastical. But mainly Levitical laws is what the foundation that the founding fathers laid this foundation on. So they don't ever talk about that this way. They talk about it from the same sense I never talk about it. Shout out to him. Metaphysically, you need to know what metaphysical is. You need to know the difference between what I do and what the metaphysical is. Coffee and Kush TV. I'll see y'all tomorrow in class, of course. And as always,